May it please, Your Lordship. My Lord, in regard to items 79 and 80, I need a little bit of accommodation from Your Lordship, my Lord. If it can be taken in the first half,
First half,
my Lord.
79 and 80.
Yes.
Oh,
Obliged.
Wait, please, Your Lordship.
all matters.
Wait, please, Your Lordship.
Yeah.
So yesterday, Lordship, my Lord, one mention, Your Lordship has allowed one mention, my Lord.
Mhm.
So due to some misplacement, my Lord, in the registry, my Lord, it just not listed, my Lord. We approached the registry, my Lord. So they asked
Bring it.
us to again mention it, my
Yeah.
Lord.
My prayer is
My,
similar
my,
to your lordship
similar
allowed
to-
yesterday.
my lord, my case was and this is the bail, my lord, it is already numbered, but it was not given
Okay.
in the list, it may be allowed
Lordship, I may
today.
allow
similar
to
prayer.
move an unlisted item today, Lordship. Highly obliged. Lordship, I have another prayer, Lordship.
Unlisted bails allowed, all allowed.
Lordship, I have another prayer, Lordship, regarding item number 6, 60 and 70. That can be taken up together along with the item number 70, Lordship.
Okay, when it
That's
comes up, we'll take it.
highly obliged.
May I please, Lordship? I beg to mention item 39, my lord. Kindly come up for vacation, my lord.
39. 39.
39, my lord.
John for the day. That's all. CD not received, issue reminder. Issue reminder. Interim is there.
Yes, my lord.
Interim extended till next date of list on
29.
29-1.
May I please,
Hello,
your Lordship?
hello.
Lordship, with the consent from other side, I beg to mention item number 21, Lordship. Lordship, in this matter, we need some time to file our objection, Lordship.
Okay, no problem.
Much obliged, Lordship.
You're for the respondent.
Yes, Lordship.
Respond, the council for respond number 2, I think.
Yes, Lordship.
Respond number 2, seek some time to file an objection, which is allowed. List the matters, list the matter in the after the view holidays on a date to be fixed by registry. Let them fix it.
Much obliged.
May it please, Your Lordship, I beg to mention item number 35 and 36. Kindly pass over for the day. Interim is given.
35 and 36,
It may come up to vacation.
because diary has been received, right? You're on interim,
Yes, Lordship.
so I think let us see it.
After vacation.
Cross check it, because the diary is there. No?
Yes.
Let it come up, then we'll decide.
Obliged.
Lordship. Lordship, with the consent from the other side, I beg to mention item number 48 of the daily list, Lordship. Lordship, CD is not here. But can it be taken up after vacation, your Lordship?
CD is not, CD is not here, we can. Rob. The case diary is not. This case diary is, it's, but this AB is pertaining to that cricket matter. Because that case diary is with me, because I have to pass one order. Actually.
Okay.
What is the PS case number?
Uh,
The cricket association matter.
yes, Lordship.
Cricket, but the diary is with me actually.
Hold on, lordship.
Diary is with me.
Yes.
Lordship, that will be taken up after vacation. Lordship. There is interim in this case, Lordship. I think interim was not there in that case.
Let's hold on. At that time, we'll
That
decide.
time we got option.
Okay.
I beg to mention item number 71. I have the instruction to withdraw this case. The
Mr.
charge
Henry,
sheet has been filed by the
Learned council. Pray 6 to withdraw this matter, which is allowed. It's post upon withdrawal.
May I please, Your Lordship? I beg to mention item number 28, Your Lordship. This is a bail hearing matter, Your Lordship. In this case, this trial court record was called for, Your Lordship. In this, as per the office note,
Not
it is
received.
not yet received.
Not received.
Let it may fix up on 20, Monday, after Bihu, Your Honor.
28.
Yeah. Scan TCR not yet stated to be not yet received. Issue reminder. Also list the matter on
20, Monday, Your Honor.
on next after reopening.
After the
Reopening Monday is 19th. You want it on 20th?
Yes, Lordship.
20th?
20.
20.
Obliged.
Thank you.
May it please your lordship, lordship item 45. Lordship, I want to withdraw the matter from the case.
Miss Huya?
Yes,
M.
Bhuya.
Learned counsel for the petition. 6 to withdraw this petition, which is allowed.
Highly obliged, your lordship.
Lordship, I beg to mention item number 34, Lordship, for adjournment. Lordship, the conducting counsel is in the hospital, Lordship, due to his mother's eye operation,
No,
Lordship.
no problem.
So
We have received a case there.
Case diary is received, but learned
a date be
Counsel,
fixed, Lordship, immediately after vacation.
your P. Bora.
P Das Lordship.
P Das Learned Counsel. Seeks an adjournment as the leading counsel is attending to
34.
a medical,
34.
is attending to a family medical issue. Full stop. Interim bail is there,
Yes,
extended
Lordship.
till the next date of listing. Case that you retain it,
Yes, it will
You did-
immediately after vacation.
19.
19 Lordship.
May I please, your lordship? Lordship, item number 66, lordship. Lordship, yesterday also it was mentioned, but the mentioning council didn't, failed to mention that the conducting council, due to medical situation, she could not appear, lordship. Lordship, immediately after vacation, lordship.
66, that is received. Please keep it. 6 an adjournment, 66 due to some medical issue, which is allowed.
It is here, Lordship.
Case diary shall be retained, list on 19.
Interim may be continued. lordship.
Interim shall continue.
Deeply obliged.
May it please your lordship, I beg to mention item number 37. I believe the case diary has not been received.
Not received.
Not received.
Kindly fix the
Case
data.
diary is not received, issue reminder. Interim bail shall
Interim.
then extended till the next date of listing. List the matter of
28 one.
Huh?
28 one.
28 one.
Deeply obliged.
May I please your lordship mention for urgent listing anticipatory bill?
Listing
Yes.
today,
After the vacation.
after the vacation.
Yes.
No problem.
May I please your lordship, I beg to mention item number 82. Lordship, can it be at 2? Lordship?
Oops, yes, no, no, no.
82 is,
At
Even
item number 82.
82 is Lordship series in port number 25.
we'll have to bring it from there.
Yes.
Right. We'll take it up in a second. Don't worry, I'll finish all the bills. I'll try my best to finish all the bills.
Lordship. Highly obliged.
Lordship,
In item number 53,
53.
76, 77, 78.
53.
53, 76, 77, 78.
Hmm.
The CD is in port number 25.
70, which are the numbers?
76, 77, 78.
76, 77, 78.
Okay, so let CD is in 25. Lordship, bill Asitsana case, I think so. So Lordship, let the matter be taken, that's Lordship. But here we have cannot produce the case day today, Lordship.
53.
But if it's a subsequent petition, then I'll have to take it.
Lordship.
Some bills were rejected earlier.
Yes,
I don't know. If they're fresh, then you can take
Then
it.
Lordship.
No issue.
but other cases,
It's flexible, you coordinate.
Lordship.
Normal procedure.
May it please your Lordship.
Yes,
Lordship,
ma'am.
483 application, the petitioners are behind the bars for last 27 days. Your Lordship, petitioner happens to be a scrap dealer. Page 13, I have annexed his no objection certificate issued by the concerned panchayat to allowing him to continue to his scrap business. Page 13, Lordship.
And just remember, they will get over. As well,
Has been issued in the name of petitioner 1. Petitioner 1 is the owner of this scrap this enterprise, and petitioner 2 is his employee, its manager, Lordship. Now I'm placing page 14, Lordship, the single list. Before placing the actual Lordship, I'm placing the page 14, Lordship. Lordship got page 14?
Page 14.
Yes, Lordship.
See the list.
So is the list. Sabir Ali. Page 14, MR number 861, that has been seized. And the place of seizure is Lordship, this Sabir Ali Enterprise. That is petitioner's business place, Lordship. So these items was removed. Now what has happened, Lordship, in course of this business, Lordship, petitioner used to receive from hawkers, Lordship, few articles, these articles, Lordship. So at best, and after receiving Lordship, so those 2 persons arrested, and police arrived, and in spite of issuing any 35 notice, Lordship, straightway arrested him, Lordship. That is a gross violation of the mandate issued by the Honorable Apex Court Lordship. Even their forwarding also reflects the same that this 35(3) notice has not been issued.
As per
So,
the forwarding report, anyway, we'll call for the diary, fix it on 19th.
Lordship,
We call for the diary and fix it on 19th.
Lordship, may I pray that Lordship already this scrap article, this scrap Lordship already been recovered, not any contraband or any other substance, hazardous substance Lordship. Only scrap, and that has already been recovered. He's a bona fide businessman Lordship, and this
No, because,
recovered
it was
place
recovered
of
from
his
his,
business.
as per the forwarding report, it was recovered from his shop upon being led by one of the co-accused.
Lordship, the co-accused that is from
Maybe an excess, anyway.
address Lordship, it did be a case for 317 that is dishonestly receiving. So for this petitioner, two petitioners are concerned because this recovery has been made from the place of his business, Lordship. That is why I have annexed. Now, Lordship, they already spent, this petitioner already spent 27 days, Lordship. Already recovered the main basic the motto of registering this case to recover the article. The article has already been recovered. The accused person has already been apprehended, Lordship. I think so far the investigation is concerned, that will be only a pleasure, Lordship, keeping them, Lordship. My respectful submission, they are bona fide person. They will cooperate, the Lordship, rest of the, because
Heard T. Som, Learned Counsel, and DP Goswami. So call for the case diary of this group, PS case number 975 of 2025. Full stop. The petitioner was arrested on 14/12. He is stated to be a scrap dealer. And as per the forwarding report, the stolen materials were recovered from his enterprise. The Learned Counsel speaks interim bail. However, at this stage, the prayer for interim stands rejected. Leave the matter on 19 March 2025.
I published it.
Hello, item 2 for timing, my lord. For timing. Yep, Lordship, my lord. Regular bail application, my lord, and in this case, my lord, FIR page 9, my lord. Here, my lord, dispute between, my lord, the informant side and one, my lord, bazaar committee, my lord. And my lord, in that bazaar, my lord, we have, my lord, purchased one shop, my lord. So we have been dragged in this case and arrested, my lord. Actually, my lord, one civil dispute is pending, my lord, before the Learned Court of Amingaon, my lord, Civil Court Amingaon, my lord. It is reflected in the FIR itself, my lord.
Case diary and medical report.
My lord.
Give immediately after petition. Don't worry. It will not be possible. Third, and so the petitioner was arrested on 1/1/2026. Call for BOCO PS 402 of 25. List call for case diary along with medical report. List on
22nd one.
Huh?
22nd also. 19 one, we have already fixed lots of methods and
22nd.
Another, my lord, 62 supplementary, my lord. One AB is there connected with this case, my lord. So in the
You are appearing in that matter?
yes, my lord. So in that case, my lord, kindly interim protection meeting, all our family members, my lord. Actually, my
I have to see this thing
my
again.
lord.
Anyway, take it up again.
60
62, right?
supplement,
62.
my lord, supplement.
We'll take it up after when it
My
comes in
lord,
the series.
published.
In the sequence we'll take it. But date will be same,
My lord.
22nd. 22nd. Case diary and medical report.
My pleasure, Lordship. My lord, he has been arrested on 8/12/2025, my lord. Today is 33 days, my lord. My lord, page, my lord, 8 is the FIR, my lord. The major girl, my lord. Promise to me and Mary and Mary physically.
A. Manaf Learned Council, 483 bail application. Chanmari PS 285 of 2025. The case arose out of FIR dated 7/12/2025, lodged by the victim woman stating about her love affair with the petitioner, followed by physical relationship and causing of pregnancy also. He alleged that he had promised her to, he had given promise of marriage, but is not fulfilling the same. Call for the case diary. However, in the interim, the petitioner is allowed to go on bail of rupees 25,000 with one surety of the like amount, with the satisfaction of the concerned learned court, subject to the condition that he shall cooperate with investigation, record his statement like not hamper sample, and shall not harm, intimidate, or harass the informant / victim. This is the matter on
31.
Huh?
301.
3030.
Interim decision.
I'm sorry, my lord, I was in Lex, my lord.
No,
Lordship, second application, my lord, earlier lordship has considered. The lordship's order is page 16, my lord. Today, my lord, 53 days, my lord, and the statutory period is 60 days here.
Paid gold. In 12.
But considering the
record.
detention, my lord, I may be allowed to go.
Paid gold record.
53 days, lordship. And the statutory period will over, my lord, on 16th. On 16th of January, my lord, statutory period will over, my lord.
Heard, Mr. Ali.
Lordship.
Here goes Sami. There's a earlier bail petition was rejected on 16/12/25 in BA 3876 of 25. About Para 234. You have mentioned about one pregnancy of
Lordship,
That is-
pregnancy of accused number one's wife, my lord. Her date of delivery
Para
is
6235. No, figure.
that is also, my lord, very difficult.
The applicable statutory period is stated to be 60 days. Call for the updated case diary. However, in the interim, the petitioners are allowed to go on bail of 25,000 each. Same conditions, hamper, temper. Not till corporate investing, not hamper, till DVDs. List the matter on, please. 30. 31.
I'm highly obliged, my lord. Obliged.
May I please, Lordship? Lordship, this application is filed under section 483 of BNSS in connection with Belso PS case number 111-2025/2025. Registered under section 109 subclause 2 and 118 subsection 2, 309 subsection 6, 35. Lordship, Bhanikolar FIR is at page 13, Lordship.
Road rage.
Lordship,
Road
road
rage.
accident letter. Lordship, there is a humble submission letter. There is another FIR which is filed by my wife. I'm a tempo driver. That is at page 16, Lordship.
16.
May I read the FIR, Lordship?
Which one? Given, first let us see the FIR which is in which you are seeking bail.
Lordship 16.
That is page 11.
Lordship 16, 16.
The particular one.
16 Lordship. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 30/11/2025 তাৰিখে নিশা অনুমান 9টা মান বজাত মোৰ ল'ৰা মহম্মদ সাহিল আখতাৰে মিলন চকৰ পৰা খোজকাঢ়ি নিজ ঘৰলৈ আহি আছিল। ঠিক নিজ ঘৰৰ ওচৰ পোৱাৰ লগে লগে নলবাৰী দিশৰ পৰা AS 148012 নম্বৰ বুলেট মটৰচাইকেলখন চালকে অতি তীব্ৰ গতিত আৰু অসাৱধানতাৰে চলাই আহি ল'ৰাক পাছফালৰ পৰা প্ৰচণ্ড জোৰে খুন্দা মাৰি পকী ৰাস্তাৰ ওপৰত চিটিকাই পেলাই দিয়ে। ফলত ল'ৰাৰ শৰীৰৰ বিভিন্ন ঠাইত গুৰুতৰ আঘাতৰ জখম হয়। জখমী অৱস্থাত ল'ৰাক 108 গাড়ীৰে নলবাৰী সাৰথী নাৰ্ছিং হোমত ভৰ্তি কৰি চিকিৎসা কৰা হয়। চিকিৎসাত ব্যস্ত থকাৰ কাৰণে এজাহাৰ দিয়াত পলম হ'ল। Lordship, the first FIR was lodged on 4th of December, Lordship. The accident took place on 30th November 2025, sorry, after 4 days, because there was some visual discussion between the parties.
It was lodged on 11 December.
11, 12,
11.
Second is lodged on 11.
Oh, this one, no. This particular FIR, which we just read.
Yes, it was lodged on 11.
Lodged by your wife.
Yes, your.
It was lodged on 11.
11, Lordship.
Now,
Because there was some discussion between the parties, the rider of the vehicle.
because
he
of the
did-
accident.
Yes, he did not have one this insurance policy, and he was a battalion person, and that's why they came for a settlement. Subsequently, some persons of their villagers suggested that yes, you go and file a case. Thereafter, they filed the case on this 4th of December, Lordship. After that, police informed us that there is a case and you come, because the public, it was a case of, Lordship, actually public assault. Because when the accident was there, I was not there. My son was there. He got injured. I got the information. I came from home. Then I rushed for hospital for treatment of my son.
Then that's why I said. Thereafter, the
Yes,
road rage
Lordship.
took place.
Yes,
Road
Lordship.
rage.
And there are the medical documents are there. And the huge bill is there, about 22,000-24,000. I'm a tempo driver. How can I manage such a huge amount, Lordship? That's why I had to take him back from hospital against medical advice. That is annexed at page 17. DAMA summary. I'm suffering in jail now. My family is suffering.
When arrested? When you got the arrest?
12th of December, Lordship.
You are Mr. Bharali.
T. Bharali, Lordship.
T. Bharali. Goswami, anything? Belsor PS case number 11111 of 25. Rubulan. He was arrested on 12/12/2025.
Lordship.
As per the FIR dated 4/12/2025. The petitioner, the informant's husband was riding his motorcycle, whereupon at the place of occurrence, the boy ran in front, due to which he was hit. Thereafter, the accused persons assaulted him. Learned counsel submits that with regard to the accident, his wife, the petitioner's wife had lodged an FIR dated 11/12 about the accident that that the informant's husband was riding motorcycle in reckless manner and crashed into her son, causing him serious injuries. Due to the treatment, there was stated to be delay in lodging the FIR. Both cases were registered. I'll call for only one case diary. Only one case diary. Call for the case diary of Belsor 11155. However, in the interim, the petitioner is allowed to go on bail of ₹25,000 once surety of the like amount to the satisfaction of that, subject to the condition that he shall not harm, harass the informant side, hamper or temporarily cooperate with investigation. Leave the matter on.
2nd of February.
We have to go into February now. 2nd of February.
Deeply obliged. Have a nice day.
6 is
May-
one, so two other, anyway, we
Your
take it up-
Lordship, 6.
we can take it up serially also.
Yes, Lordship, this case, Lordship will
But
remain
submission need not be repeated.
repeated.
Your submission.
Yes,
That will be
Lordship,
slow. Today we have time
lots
constraints.
of
We
cases.
have to go fast.
Lordship, whatever in this case, Lordship, probably remember, Lordship, the police personnel in a civil uniform, Lordship, they have picked up a person, Lordship, Baharul Islam, Lordship. And then that person, Lordship, raised halal, Lordship. In the meantime, Lordship, the cricket match was going on, Lordship. The people gathered there, Lordship. they doubted regarding the identity because this police personnel did not show their identity card,
I
Lordship.
remember this. I think
That case,
that's,
Lordship.
okay. So that diary must have come, no?
It is coming from
Because of the another item is there, Lordship. 60 is
Hmm.
anticipated bail and 70 is the regular bail.
Anticipatory, we had called for diary, I think.
Yes, Lordship. Some protection, Lordship.
So,
In regular bail, call for the diary, Lordship. Item number 70, Lordship.
70.
Yes, Lordship. 70.
We can take it up after some time.
Lordship, in the interim, kindly, because these are the village people, Lordship, let them enjoy
70 is
the.
bail hearing.
Yes.
Diary must have come.
Yes.
We'll look at the diary after some time.
Lordship,
Let us
diary
finish the
is-
motions. I will look into it. This will be tagged up with the bail hearing. And the single motions, let us finish first.
Obviously. Along with this 66 will be taken up with the 70.
No, dear, I mean, all of this one. 66 hour, 70. We have to do all the bails. No bail should be left unheard.
Lovely, good Lordship. So this is regular bail application, Lordship. In this case, Lordship, the FIR will find page number 9, Lordship. And operating person will be start from Lordship page number 11. And apparently the contents of the FIR, Lordship, and some fake gold and fake currency is recovered from the accused person.
So CD may be called
So
for
67 days in custody, Lordship.
Let us say call for the city only.
And Lordship, and one Lordship, and there is a required one small correction, Lordship, in sections. If you kindly post page number 1, Lordship. 61. 61, it should be only 61, but subsection 2 is over. Excessively written.
Only 61.
Only
No.
61.
Applied whitener.
Lordship.
No problem.
Obliged, Lordship. Obliged.
State call for Jalukbari PS case number 441 of Pune. Arrested on 311. Date
21-1.
21-1.
Obliged. Obliged.
Your Lordship, CD may be called for, Your Lordship. 45 days behind bar. Altogether 70 days, Your Lordship. In this case, he was shown arrested.
Case diary will be has to be call for.
Call for Lordship.
Dispute PS.
No, this
Morigaon PS.
Morigaon.
22nd.
Heard as Bhattakur Land Council. Call for the case diary of Morigaon PS case number 266 of 25. He was arrested on 25/11/2020. Please stop.
22-1. 22nd.
Is it okay for you?
Lords.
53 again, is it?
53, Your Lordships may take it up along with Your Lordship. 76, 77, 78, Your Lordship.
After some time.
CD is in court number
With the seat.
25.
Lord.
Oh, you want-
76, 77.
Shall I take it up now?
No, Your Lordship, along with those matters. Your Lordship
Along with
may
those
take
matters.
Some. Lords.
Here, my lord, it is a contractual dispute, my lord. What amount is around more than 4 crores allegation. So, my lord, it is from Jorhat, my lord, Lordship will kindly pleased to call for the case diary, my lord. But it is purely a contractual dispute, my lord, absolutely civil in nature, my lord. But possibly Lordship would want to go through the diary once, my lord. Some amounts are due, my lord. We have also paid some amounts, but some other amounts are awaited, my lord. So this FIR was lost, my lord. We have annexed most of the document. Lordship will call for the case diary, my lord, fixing a short date, my lord, because my lord, it is absolutely a civilian dispute with civilian nature.
Why was he arrested then?
No, arrested because they say, my lord, that disputes were there and that money not, my lord, page 27, my lord.
Let us briefly see the FIR once.
My lord.
Let us briefly see the FIR once. Delaying investigation. Which was please.
My lord, page.
Any fraudulent activities alleged?
Yes, my lord.
Fraudulent.
Yes, sir. Fraudulent in a sense the money was not returned. That much.
That's
also fixed on 19th, my lord, then it will be clear, my lord, because today last day, my lord.
That's okay. Nice of you. The petitioner was arrested on 30/12/2025. In connection with Kiok PS case number 146 of 20. Call for the case there. list on
19, not 20,
My-
20, Lordship,
my
21.
friend said 20th, my-
20,
20 will fix many matters, I think.
and 21 then.
20.
19 only the reappointing time we have to communicate today.
20.
20.
20.
And 21 also can.
You decide. No, you decide,
Highly of
because I don't know. 20.
20. Highly of
May please your lordship. Okay, here the petitioner was arrested on 6/10/2025, as on date lordship 96 day. Lordship may kindly come to page number 15, lordship FIR. This FIR was lost on lordship 6/10/2025. My lord may kindly note the date lordship 6/10/2025.
10.
The Hafal submission is that on 11/8/2025 at around 10 a.m. my minor daughter named so-and-so aged about 17 years while she was on her way to school was taken by car applying inducement upon her by the below named accused person. While searching our daughter, we found her at the house of the accused person and tried to take her back to our house. But the accused person has threatened us and accordingly we driven away. Then we called the village visa but failed to get any remedy. In the hope of village visa, delay is caused in lodging the FIR. This is the FIR lordship lost after 2 months almost. Now, my lord may kindly come to page number 28.
Just a minute. Charge sheet under 143, 140, right?
I'm coming to the
What is that
lordship.
section?
Charge sheet, lordship may kindly come to the charge sheet. Page number 23.
Okay, no problem.
Charge sheet here, lordship, at the very beginning, under section 140 subsection 3, that is punishable up to 7 years, and 142, that is also 7 years. Now, my lord, may kindly come to page number 27. Very interesting, lordship. Page number 27. Second line. The honor recovered the victim girl and done her medical examination by the doctor so-and-so, produced her before the Honorable Court of Sribhumi and recorded her statement under section 183 of BNSS. And thereafter, the victim girl has been handed over to the legal guardian as per the order of the Honorable Court. Recorded the final statement of the complainant under section 180 of BNSS. Medical report of the victim girl is yet to be received. During inquiry, the previous IO has arrested the accused person, namely so-and-so, for the commission of offence under section 140 subsection 3 and 142 of BNS. On interrogation, the accused person confessed his guilt. Till then, lordship, everything was fine. So the accused, namely so-and-so, has been arrested and forwarded to the jail custody for commission of offence under section 143 subsection 3. Lordship, this is a typographical error. I have the submission with this. He was forwarded. His forwarding report says 140 subsection 3. Here, lordship, suddenly 143 subsection 3. And even, lordship, as per the ingredients, this section is not applicable in this case. On completion of investigation, a prima facie case under section 143(3) and 140. Now 142 is missing here, lordship. Have been found, established against the FIR named accused person. Now, lordship, may kindly come to the order dated 6/12/2025, page number 35.
I've seen her 164.
Yes, lordship.
I've seen it already.
Page number 30.
Let's call for the
My
scan.
lord, may kindly peruse the page number 30, lordship.
Lordship, that's one total. Statement of the victim, lordship.
Statement of the victim.
I've seen it.
Yes, lordship.
And then, lordship, may kindly come to the charge framing order. Page number 35. Charges are framed under section 143(3). It cannot be, lordship. Lordship, may kindly come to page number section 143(3) for a moment. Trafficking of person, now subsection 3, where the offense involves the trafficking of more than one person.
Wrong. Anyway.
Even if, lordship, if we assume that the entire FIR is true, then also, lordship, 143(3) will not come. And this is not a case of session tribal, lordship. The session just has wrongly framed the search. And Lordship, so far as section 251 CRPC is BNSS is concerned, Lordship, it was the duty of the learned session judge to transfer the case once again back to the learned CVM, Lordship. As because, Lordship, the offense is exclusively triable by the court of.
Yeah.
Lordship, may I pray for interim, Lordship?
M. Mohammed.
Yes, Lordship.
DP Goswami. The petitioner was arrested on 6/10/25 in connection with Ramakrishna Nagar PS case number 74 of 2025, which was tertiated upon completion of investigation and registered as sessions case number 231 of 25 dash 31, in which charges have also been framed. There is the statement of the girl stated to be aged 17 years before the learned JMHC, in which she stated about going away with the petitioner, with whom she was having a love affair. Call for the scanned copy of the case diary and charge sheet. However, in the interim, the petitioner is allowed to go on bail of 25,000 once of the like, with satisfaction of the concerned learned court, and subject to the condition that he shall not cause any annoyance or harassment of the victim girl. This is the matter on 2/2 February.
2nd February.
2/2.
Highly obliged.
May please also. My lord, regular bail application, my lord. FIR is at page number 17, my lord. May I read the vernacular, my lord? 69 offense, my lord. 69 BNS. 69 BNS, my lord. সন্মানপূৰ্বক বিনীত নিবেদন আপোনাক জনাও যে মই লছিমা গাঁৱৰ বিধৱা মহিলা হওঁ। মোৰ দ্বিতীয় ছোৱালী মই সুমি চুলতানা উক্ত 1 নম্বৰ পদকীয়াজনে বিয়া কৰোৱাৰ প্ৰলোভনেৰে যৌন নিৰ্যাতন চলায়। জানিব পাৰিছো উক্ত পদকীয়াজনে অইন পৰিয়ালৰ ছোৱালী বিয়া কৰাৰ প্ৰস্তুতি চলাই আছে। উক্ত খবৰ পাই মোৰ ছোৱালীজনীয়ে উক্ত 1 নম্বৰ পদকীয়াজনক পুনেৰে সোধপোছ কৰে তেতিয়া সি মোৰ ছোৱালীজনীক তাৰ ঘৰলৈ আহিবলৈ কয় আৰু সেই মৰ্মে তাই আহি যোৱা 20/12/2025 তাৰিখে পদকীয়াৰ ঘৰ আহি বৰ্তমান তাই তেওঁলোকৰ ঘৰতে আছে। তাইক এতিয়া 2 নম্বৰ পদকীয়া আৰু পৰিয়ালৰ অন্য সদস্যসকলে ঘৰৰ পৰা বাহিৰ কৰি দিয়ে আৰু নানা ধৰণৰ অত্যাচাৰ উৎপীড়ন কৰি আছে। So, my lord, from the very FIR, my lord, it shows that my lord, the girl was invited by the petitioner himself. And because of some other reason, most likely from the objections by his family, my lord, family members, the girl was driven out from the house of the petitioner.
They had Biar Prolobon di.
Biar
about rape.
No.
Can you read that part again? Because handwriting is
Yes, yes. মানে মোৰ দ্বিতীয় ছোৱালী মই সুমি চুলতানাক উক্ত 1 নম্বৰ পদকীয়াজনে বিয়া কৰোৱাৰ প্ৰলোভনেৰে যৌন নিৰ্যাতন চলায়। জানিব পাৰিছো উক্ত পদকীয়াজনে অইন পৰিয়ালৰ ছোৱালী বিয়া কৰাৰ প্ৰস্তুতি চলাই আছে। উক্ত খবৰ পাই মোৰ ছোৱালীজনীয়ে উক্ত 1 নম্বৰ পদকীয়াজনক পুনেৰে সোধপোছ কৰে তেতিয়া সি মোৰ ছোৱালীজনীক তাৰ ঘৰলৈ আহিবলৈ কয়। From the intention, my lord, it appears, my lord, from the FIR itself. It is the petitioner who had invited the girl to come to his house. But if he had no interest, my lord, why would he have invited the girl, my lord? And regarding, my lord, section 69, regarding promise, there must be intention not to fulfill the promise from the very beginning, my lord. But the FIR itself shows that, my lord, he had himself invited the girl.
But she stayed for some time.
My lord?
She stayed in his house for some time.
Yes.
Some days.
Yes. Thereafter, my lord, what happened? The girl's own family members came to pick her up, and there was some dispute between family members of both the sides. That's why, my lord, the girl was taken away and this FIR was lodged. That is why, my lord, in the FIR
But statement is not available.
Not available. So, statement is required.
As does Learned Council and DP Goswami. The petitioner was arrested on 23/12/25 in connection with Mukal.
17 days, my lord.
Fokalmoa PS case number 272 of 2025. Sumit versus State of Delhi. The fire was lost by the girl's mother on 22/12/2025 with the allegation that the petitioner had committed
Sexual assault, man.
sexual assault
Sexual
upon-
assault.
upon her daughter with a promise of marriage. And later, when she heard about he's trying to marry another girl, she telephoned him. Whereupon the accused petitioner called her to his house, where she stayed for some days. Stayed for some days. It is alleged that later his family members drove her out.
3 days, man.
3 days, few days. Call for the case diary, however, in the interim, allowed to go on bail of rupees 30,000, one security, subject to the condition that he will not cause any harassment or harm to the informant or the victim. This is the matter on 2-2.
But there is small typographical error in the prayer, my lord. The PS case number ought to have been 272. We have been mentioned as 271.
Yeah, that we have to correct. Wrong CD will come.
Yes.
272.
272.
Actually,
Yes.
here you have written correctly.
Yes.
First title is correct.
Yes, in prayer portion only.
No. 272.
Highly obliged.
2nd February.
It is also a report was called for whether any case is registered against this petitioner Lordship. So we have not received a report Lordship.
In terms of order dated 19/12/2025, report was called for from the concerned police station regarding registration of any case against the petition. However, the report is not yet received. Issue a fresh reminder for the same. Any interim order is there? What is the
No.
allegation?
Nothing in the means only that in the event of any case registered, the petitioner should be told on case number.
Till
Last-
the returnable date, the petitioner may not be subjected to any coercive measure. Okay. Next.
21, 201,
22.
20, 20.
Who's your?
Only for a report Lordship.
Deeply obliged.
May I please your lordship? Lordship, this is a search sheeted case. 302 is there and it is in the committal stage. Your lord, there were 2 persons shown to be absconded. Your lordship has granted interim to one of the person that I have annexed at annexure 4, page 26. The absconders were Jalil Ali and Sanwar Hussain, out of which the Sanwar Hussain already been granted interim by this honorable court. Your lordship has granted it. Annexure 4, page 26. So that my prayer is that I may be allowed to some interim protection so that I can appear before the committal magistrate.
Mr. Tamuli.
Yes, Lord.
Page 26. There are 2, 3, 4. There are 2, 3 is same. 2, 3 is only 2, 3. The Mr. Learned Counsel submits that similarly placed co-accused was granted interim bail in his bail application. Interim bail in his bail application. By order dated 19/12/25 passed in AB 3006 of 2025. If case is fixed on when 27/1.
27/1.
Fixed on same day.
Yes, Lordship.
Call for the case there of this.
Charge sheet already.
Charge sheet at this. Call for the, it is here what we don't. Call for the scan
Can
copy
be
of
tried for
PCR of this.
PDN and
List on 27/1.
Lordship,
27.
in the meantime, interim may be granted. So that I can appear before the trial.
Oh, yes. Yes, actually, interim thing. You need not appear. The investigation is complete now, but you can appear if you
No,
want.
I will have to appear before the committal
Yeah,
magistrate
yes.
because it is committal stage. That
You
is
can
why-
still appear if there is any further investigation. Otherwise, no.
Lordship.
Yeah, won't you appear? 27/1. Along with that, it will be taken up together.
Lordship,
27/1.
the interim.
Interim protection.
Much okay.
Interim protection. People if you got it, interim protection. Same terms.
May I please your lordship?
Yes.
Lordship, this is a circuited matter, my lordship. Lordship, in this NTW is issued, my lordship. It's a states of appearance, my lordship. My lordship, as it is before, as 307 was later on in the circuit added, my lordship, it would before the court of session would have the power to grant bail. So, my lordship, the petitioner is apprehending arrest with regard to on his appearance. He may be granted with an opportunity, my lordship is ready to face the trial. And in this case, what happened was that initially he has filed bail before charge sheet, my lordship. He was granted interim, and I have also annexed those document. And on the date of case diary,
The same was rejected.
no, my lordship, it was been submitted. That FR was submitted by the PP side, and so it was. I have.
Okay.
So for that reason, he was on apprehension that FR was submitted.
Okay.
And that order also I have annexed, my lordship, at page 21, annexer 4.
Actually, FR was not submitted. Charge sheet was submitted.
Charge sheet was there. And so, my lordship, he wants to phrase the trial, my lordship, and he is apprehending that since the SDSM has issued the PRC case and it is before the court of session, that would be power with regard to 307, my lordship.
H.C. Borua, learned counsel for the petitioner and VP Goswami. The petitioner is seeking this bill in connection with. What is the PS number?
PS
Not
case
looking for PS case number
and not looking for PS case number 446 2021.
21. Which after investigation was charge sheeted and thereafter pending for appearance by way of PRC number 442 of 2020. Copies of the charge sheet have been annexed. It is submitted that the petitioner undertakes to cooperate with the trial. Call for, should we call for scan copy?
Yes, absolutely.
Call for scan
But-
copy of
but
case
he-
diary and charge sheet.
My lordship, one
Not necessary.
submission, my lordship, he wants to face the trial. In that case, if my lordship, because
No, should I dispose it of?
ma'am,
Huh?
Lordship,
Should I dispose it of or call for the?
for
case?
the records and let him appear before our
Yes,
trial court.
I'll give you
Yes.
yes. Call for the scan copy of scan TCR comprising case diary and charge sheet. However, considering the stage of the case and undertaking on behalf of the accused, it is directed that in the event of his arrest in connection with this case, he shall be allowed to go on bail of rupees 30,000 once surety of the liability, subject to the condition that he shall cooperate with the trial if one commences and appear before the learned court bill. List on
3rd February.
3rd February. But the allegation is not good. It's okay. Interim,
yes. My
allegation
lordship,
is
it
not
fixed before the trial court on 11th of February.
11th of February.
Yes.
So, yeah.
Obliged, my lordship.
Allegation is not good that he went for Bihu Chanda and then he was hit on the head with a
Yes.
tokan or something.
Yes,
And then
my
he had to do a CT scan.
Yes, my lordship. Obliged.
FIR, your lordship will find at page 13.
Page 13.
Page 13. This FIR was lodged by chairman of municipality, lordship municipality. And relevant portion of lordship will find page 14. Basically, there are allegations in the FIR is that the petitioner along with another person lordship collected house tax and other taxes lordship, and they have not deposited the entire amount in the accounts lordship. That is the allegation in the, but if your lordship peruses page 14 and 15, your lordship will find that they have not mentioned any specific amount or year on which these misappropriations were conducted. In my humble submission, lordship, this is only the suspicion regarding the anomalies, lordship. And even if your lordship turns to page 15, these three names are given. This is the illustrative examples of fraud. These are not they have not said that these are the persons.
So these two persons, but anyway, any bail petition is pending because we have touched this matter. Otherwise, just call for the case then, fix it immediately after reopening. Immediately after
Some
reopening.
protection will be given
No.
because lordship, already he is suspended from lordship and
That's
all,
true, but,
all records are in the office. And
Nature of the
there,
allegations, I'm sorry.
there is no
it will
chance
not
of
be possible.
manipulating those documents. That is
No.
there.
It will be. Give him a short date. Sribhumi PS case number, call for CD 500 of 25. That's all. List on,
22nd one.
22nd.
It's from Sribhumi Lordship.
How do I go?
Please, my lord. This is the 482 application, my lord. Allegation against me, my lord, 69 and 89 of DNS. Page 10 is FIR, my lord. There is a love relation between my lord petitioner and my lord victim, my lord. Then, my lord, there are some, the allegation is that miscarriage was done. One affidavit is done by the victim, my lord, page 14, my lord. The matter was compromised, my lord.
They were living together as husband and wife, isn't it?
Yes, yet not.
According to
my
our
lord.
statement.
Yes, my lord. But marriage was not happened, but living together as husband and wife.
Living.
Yes. Now matter also compromised, my lord. Page 14 is affidavit. My lord. Page 15, that is on.
Anybody is appear from on our behalf? Nobody is. You are Mr.
M. Kolikant.
M. Council, DP person. The petitioner is apprehending arrest in connection with Gopur PS case number 127 or 25 and has preferred this application under 482. The FIR was lodged on 18/12/2025 by the victim girl herself with the allegation that pursuant to their love relationship for 10 years, for the last 4 or 5 years, she and the petitioner were living together and having physical relationship. The rest of the allegations are about her becoming pregnant and the accused giving medicines to abort the same. All for the case diary. It is the learned petition. Mr. Kolita, learned counsel, has drawn my attention to a copy of affidavits purportedly made by the informant girl, by informant/victim girl. Indicating her intention to amicably settle the stating that she has amicably settled the matter. Well, for the case there, however, in the interim, the event of his arrest, 25,000 is considered the satisfaction of the arresting authority, subject to the condition that he will cooperate with the process of law. List on
3rd of February.
3.
Okay.
My lord, 482 petition. Lordship, charge sheeted matter, my lord, court has taken cognizance, my lord, and issued summon. My lord, problem is, my lord, I have been shown as a absconder accused, my lord. And the next date on 25/2/2026 for appearance, my lord. Some protection may be provided, my lord. I'll face the trial, my lord. Case 20, my lord.
M. Ali, DP Goswami.
326 are there.
In a case arising out of Dhing PS case number 209 of 23, the investigation resulted in a charge sheet. Charge sheet against the accused under section 341, 326, 34, right?
Lordship.
IPC. And summons has been issued, due to which the petitioner is apprehending arrest due to the presence of section 326 IPC. Stop. All for the scanned TCR comprising case diary and charge sheet, including medical report if any. However, in the interim, 30,000 is conservative inspection, subject to the condition that he shall appear before the learned court below and he shall not cause any harm to the informant side or victims. This is the matter on 3-2.
3-2.
Obliged, my
So sometime. 40? You're for 40? Okay.
Time leba,
Not here.
Pending conversation.
After some time, we'll take it.
Wait, please, madam. 482 application, my lord, FIR is page 14, madam. My name is not in FIR, madam.
Several sections, no? Explosive substance.
Yes.
Yes.
What is the allegation? You can read the FIR.
Yes, madam. Sir, I, SIP, Atul Das presently posted at Joysagar OP, respectfully submit the following your information and necessary legal actions. That on 9/8/2025 at approximately 6:30 PM, I received via telephonic information that one dumper burst while welding the vehicle in a godown belonging to the owner, Jalil Ahmed, and two of the workers, namely Muzakir Ali and Abdul Jalil, had sustained serious injuries and now admitted at Brahmaputra Hospital, Dibrugarh. During the inquiry, found the modified dumper which was converted into a tanker where the burst took place, with the tin sheets and the large quantity of suspected crude oil petroleum class A was found to have been illegally stored in a godown situated at Singadwar Sariali, alleged to be jointly owned by the Jalil Ahmed and Abdul Ahmed, without any valid license and authorization from the competent authority. It has been further learned that the crude oil is concealed in a specially constructed underground chamber, which is covered with reinforced concrete flooring to prevent detection. This hidden storage arrangement indicates an attempt to evade inspection and regulatory oversight. Crude oil being a highly inflammable and hazardous substance, such unauthorized storage poses a serious risk of public safety, nearby residential and commercial properties, and the environment. It is also contravention of Section 3 and 4 of Petroleum Act 1934, read with Rule 4 of the Petroleum Rules 2002. The deliberate concealment of the petroleum product undersigned and is joint possession by the above name owners suggests a criminal conspiracy of under Section 61B BNS. Their act amounts to negligent conduct with combustible and explosive substance as per Section 287 and 288 of the BNS 2023. There is a high probability of involvement of a nexus involving the theft, storage, and transformation of crude oil from Shivsagar to other districts, as well as to end user within Shivsagar district. Here, my lord, owner is Jalil Ahmed and Abdul Ahmed. My lord, my name is, my lord, Papu Borga. I raised some question from FR name accused persons, my lord. Page 5, para 5. I have stated my lord, what is my role, my lord?
The case is charge sheet? No.
No.
Case 5.
Yes, my lord.
There are 5.
Yes. Middle person. The petitioner is an active social worker who recites his voice against the FR name accused persons for their illegal activities. Yes, my lord. And my lord, your lordship already granted bail, anticipatory bail case if they some of the co-accused.
No materials were
Yes,
found
yes,
against them.
yes.
Anyway, let him record his statement.
Yes.
You're Mr.
M. Kolita.
No, I'm Kolita. M. Kolita Learned Council. You know about it, two people, it's not budget, tell you. Page 50. Page 50. There are 2, 3, and 4. 3 and 4. Mr. Kolita Learned Council has drawn my attention to para 5 of his bail petition, wherein it is stated that the petitioner, apart from not being FIR named, is an active social worker who had raised his voice against the FIR named accused persons for illegal activities, and that he has no relation with the state persons or the offense or state person. Full stop. It is denied that the petitioner is involved in the alleged offenses. All for the case diary of Shivahagar PSK 119 of 25. However, in the interim, 25 happened 102. will cooperate, appear before the IO for examination, not hamper temporary activities. 4-2.
4-2. Your Lordship.
Hey, please, Your Lordship. There's an anticipatory bail application under 482 BNSS. Lordship, the vernacular FIR is in page 16, Your Lordship. May I read?
Yes.
Ejaharkari Banojit Kumar
Page
Das,
16.
page 16, Your Lordship.
The original one.
Original one, the vernacular.
Mm.
Ejaharkari Banojit Kumar Das, Bonopalok Ek Khondo Bonobikhoya পাঠশালা মহাশয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ইংৰাজীৰ 13-12-2025 তাৰিখে মই আৰু খণ্ড বন বিষয়াৰ কাৰ্যালয় পাঠশালাৰ বনকৰ্মী আৰু আঞ্চলিক বন বিষয়াৰ কাৰ্যালয়ৰ বৰপেটা ৰোডৰ বনকৰ্মীসকলক লগত লৈ আবেলি প্ৰায় 3 মান বজাত টহলদাৰী কৰি থাকোতে দলগাঁৱৰ কুৱাৰাৰ কালদিয়া নদীৰ পাৰত অবৈধভাৱে পলস মাটিৰ খনন কাৰ্য পৰিলক্ষিত হয় উক্ত খনন কাৰ্য দেখি আমি ঠাইখিনিত উপস্থিত হৈ মাটিৰ দম আৰু এখন এক্সকাভেটৰ ৰখাই থোৱা দৃষ্টিগোচৰ হয় উক্ত খনন কাৰ্য চলি থকা ঠাইত কোনো ব্যক্তি পৰিলক্ষিত নোহোৱাত আমি গাঁওবুঢ়া আৰু স্থানীয় ৰাইজ কমিটিৰ সভাপতি সম্পাদকৰ লগত কথা পাতি জানিব পাৰো যে দীপাংকৰ চৌধুৰী বুলি এজন ব্যক্তিয়ে মাইনিং পাৰ্মিট থকা বুলি উক্ত ঠাইত খনন কাৰ্য চলাই আছে উল্লেখ্য যে আসামী দীপাংকৰ চৌধুৰী মাটি পটা আৰু মাটি পৰিবহন কৰাৰ কোনো বৈধ পাৰ্মিট নাই গতিকে আসামীৰ কোনো বৈধ পাৰ্মিট নোহোৱা বাবে আমি বন বিভাগৰ ফালৰ পৰা এক্সকাভেটৰ আৰু খনন কৰা মাটিখিনি জব্দ কৰিছো This is the allegation, Your Lordship. But the FIR is lodged under section 3032, that is theft, and 317(4), that is dealing with stolen property. And moreover, 2 more sections of the Assam Forest Regulation Act is also attracted, that is section 40 and 41, Lordship. And 41 is up to 3 years punishment. And 40 deals with power to make rules to regulate transit of forest produce. And 41 is the punishment for not abiding section 40 of the Assam Forest Regulation Act. And section 41 is bailable in nature as because it is of not exceeding imprisonment for a term which may extend to 3 years, Your Lordship. So basically 2 non-bailable sections are there, that is 3032 theft and 317(4), Your Lordship. But from the mere reading of the FIR, we can see that these 2 sections are not attracted. It is here in the FIR, the informant is alleging that I am I having no permit, I am doing mining, Your Lordship. But in page number 18, annexure 2, that is the mining permit, Your Lordship, which is provided by the government of Assam Directorate of Geology and Mining. Page number 18, Lordship.
No problem.
So I may be protected
No problem.
till the CD comes, Your Lordship.
That's learned counsel and DP Kosan. All for the case diary of Arasar Kusi PS case number 230 of 2025. The so and so. The gist of the allegation in the FIR dated 13/12/2025 is that one abandoned excavator was found, and later it was found that the And it is alleged that later it was found and that the petitioner is using excavating with that without valid papers. Learned counsel with the learned counsel sir has taken the court to the relevant annexed documents, including document purportedly a permit in his favor regarding such excavation. I have also perused the document given on behalf of one MS Imperial Corporation and also a copy of a formal work order. She submits that the penal provisions of BNS given are would not be applicable, you said.
Yes, Your
Would not be
Lordship.
applicable, and the two provisions of the Assam Forest Regulation are bailable.
Regulation Act.
Available.
Bailable.
Are bailable.
41 is bailable.
Nevertheless, call for the case diary. However, in the interim, he shall is protected 25,000 once your corporate investigation appear before the IO, making itself available for examination and also submit his necessary documents.
Only thing is the permit is for specific area, but in the FIR, what is the
Well,
specific area? Yes.
He may be doing
The
it in
FIR does not
another-
mention the specific area. So 4-2.
Lordship.
May please, Your Lordship. In the subsidiary case, petitioners are declared as absconder, my lord. The petitioners are willing to cooperate with the proceeding. FIR is paid, my lord, the page 15, my lord. May I read, my lord?
It's a case of robbery.
Robbery.
That's the problem.
My lord, most of the accused, my lord, arrested and subsequently released, my lord. Only the petitioners and one Russell declared absconder, my lord.
So what should we see the records or pass some interim order?
See the records.
Dacoity and all these cases at
Yes,
midnight, they.
No, at my lord,
1 PM afternoon, whatever.
1 PM, my
Public
the
safety
daytime, my
matters.
lord.
Public safety matters are, they stand on a slightly different, footing in my humble opinion, but anyway.
Must
committed robbery. Call for the case record, scan TCR of comprising case diary and charge sheet of South Mankasar PS case number, Mankasar PS case number 620 of 2025. Within bracket, PRC 418 of 24. Stop. The learned code below. List you give after the vacation, you give
27.
7.
Highly appreciated.
May I please allow the pre-arrest bail, Lordship. Let us come to the FIR first, Lordship. That Lordship will find on page 12. Annexure 1. May I read it, Lordship?
Yes.
Most respectfully beg to state that I am a widow woman. Since last 2 months, I have been staying in the house of the Mohibur Rahman, situated at the backside of Suja Bike Showroom near Doboka SBI. The below mentioned accused person has stayed on rent at the house of Mohibur since 1 month. The accused is a private engineer. The below mentioned accused person since 1 month has often established physical relation with me by inciting me. My son knows the incident. Thereafter, the accused left the rented house on 13 November to 10 AM without telling me anything much. Moreover, both are major lordship, the constitutional lordship, and moreover, and the fact of the case that some monetary transaction was there between them, lordship. The victim, as an informal lordship, she have borrowed some money from me, and she did not return it me, lordship. When I have asked for returning, the resultant is this, lordship. Otherwise, lordship, both are major, and it is consenting party, lordship. Regarding that force and that has not been said. Yes, force promised to me, nothing, absolutely nothing in the content of the answer.
Yes, Murid and Vigo sir. Stop. Roboca PS case number 32 of 25. That's why the gist of the allegation, the FIR lodged by the victim moment is that the petitioner was tenant in a nearby house, was having ill relationship with her by enticing her, and thereafter he left the place without telling her. Call for the case there, however, in the interim, 25,000 is considered. He will not cause any annoyance or harassment or harm to the informant. This is the matter on 4-2.
4-2.
Right? 4-2.
4-2 Lordship.
4-2. With interim protection.
Lordship, much. Can it be on 3-2 Lordship? 3-2.
3.
Much obliged.
May I please the Lordship? The anticipated bail application, Lordship, offense, Lordship, under section 318 and 316 of BNS, Lordship. The Lordship, FI case 12, Lordship. I'm reading the FI, Lordship. With due respect, I would like to inform you that on 27/5/2024, at the Solar Finance Office in Bilasipara, my Alto car bearing number, registration number so and so, was sold for rupees 90,000 to the accused number 1. After discussion, while sitting at the showroom through Khurshid Ali, a boy walking in the showroom located at so and so. It is stated that the said accused agreed to pay the monthly installment of the said vehicle, and paying rupees 90,000 to the owner of the vehicle, took delivery of the vehicle from the showroom. Thereafter, after lapse of 8-9 months, the accused did not pay the installment of the vehicle. Upon making inquiry, it came to know that the accused had sold some other vehicle in the same manner, Lordship. It is the allegation, Lordship. Here, Lordship, the present petitioner is a businessman.
What did he say? Actually, I do not get it completely. That vehicle was?
Vehicle was
money
sold,
was
Lordship.
given.
Yes, Lordship, I am doing the business, Lordship. Purchase of used vehicle and sold to the other purchaser,
The
Lordship.
discussion while sitting, the boy stated that he agreed to pay monthly installments of the same vehicle. That means it was
Higher purchase vehicle.
higher
Yes, Lord.
purchase.
Yes, Lordship.
So anyway, so thereafter,
Promising to pay the installments.
Therefore, Lordship, I am a businessman, Lordship. I purchase vehicle and sold to other purchaser, Lordship. Here, Lordship, actually, the person who purchased the vehicle, Lordship, he is my customer, Lordship. He is a Dibrajyoti Bora from Guwahati, Lordship.
just a minute.
And the purchase and
It is typographical error or what? I just FIR was lodged on
24, Lordship. In the year 24, Lordship. The incident took place on 27/5/24, Lordship. FIR loss, Lordship, 25, Lordship. 9 September 2025, Lordship.
13/9
Yes, Lordship. After 1.5 years, Lordship.
of the LS incident.
LS incident, Lordship.
It's sold for 27.
Vehicle also
Lordship,
missing.
Lordship, both the section is compoundable, Lordship. So, Lordship, I will appear before the IO, Lordship. Is there documentary evidence, Lordship? There must have some document executed
I
by
don't know. They have
between the
indicated
parties, Lordship.
that about cheating. Anyway, that's also a lot after a long time. Third A. Borua Land Council and Mr. A. Borua
Yes, Lordship.
and DP Goswami. Bilasipara PS case number 383 of 25. The FIR was lodged on 13/9/2025. With the allegation that on 27/5/2024, at one solar finance office in Bilasipara, the informant sold this Alto vehicle for 90,000. And that the accused agreed to pay the monthly installments. And thereafter took delivery of the vehicle, but after 8-9 months, he did not pay the same. And later, the informant came to know that he had sold other vehicles also in the same manner. However, as rightly pointed out by the learned counsel, the FIR was lodged about more than a year after the alleged incident. It would be fair to allow the petitioner to get his statement recorded. However, call for the case diary, but in the interim, 25,000 at one security. Cooperate and cooperate the investigation here before the higher for recording still. This on 4-2.
Last surprise.
May I please, your lordship? This is an application under section 2. FIR, your lordship will get it at page 16 euros. May I read your lordship? May I read your lordship? বিনীত সন্মানপূৰ্বক নিবেদন এই যে 15/12/2025 দিনা মই শ্ৰী প্ৰাঞ্জল বৰাই মোৰ কন্যাক স্কুলত থৈ ঘৰলৈ যাওঁতে দগাঁও হাইস্কুলৰ সন্মুখত অসম জাতীয়তাবাদী যুৱ ছাত্ৰ পৰিষদৰ যোৰহাটৰ সাধাৰণ সম্পাদক বিশ্বজিৎ জ্ঞানৰ তেওঁৰ ককায়েক দীপক জ্ঞান দুয়ো মিলি ভোগদৈ
Take the microphone once.
Lords,
hearing problems.
it's working.
You want to read the English or the
The vernacular, one sentence in India.
It's always better. Yeah.
লিখিত সন্মানপূৰ্বক
I'm
নিবেদন
at page 16 now.
16
We need to সন্মানপূৰ্বক.
নিবেদন এই যে টাং 15/12/2025 দিনা মই শ্ৰী প্ৰাঞ্জল বৰাই মোৰ কন্যাক স্কুলত থৈ ঘৰলৈ যাওঁতে দগাঁও হাইস্কুলৰ সন্মুখত অসম জাতীয়তাবাদী যুৱ ছাত্ৰ পৰিষদৰ যোৰহাটৰ সাধাৰণ সম্পাদক বিশ্বজিৎ গায়নৰ তেওঁৰ ককায়েক দীপক গায়ন দুয়ো মিলি ভোগদৈ নদীৰ পৰা অবৈধভাৱে মাটি আৰু বালি ডাম্পাৰ খনন কৰি গাঁৱৰ তথা আজৰণি ঘাটৰ পৰা দগাঁও হাইস্কুলৰ সন্মুখৰ ৰাস্তাভাগ একেবাৰে শোচনীয় কৰি পেলাই। যিহেতু এই ৰাস্তাটোৱে আমাৰ অহা যোৱা কৰোঁ, ৰাস্তাটো বেয়া হোৱাত মই বিশ্বজিৎ গায়নক অতি নম্ৰভাৱে কওঁ যে আমাৰ ৰাস্তাটোত ইমান ডাঙৰ ডাম্পাৰ চলাই কিয় বেয়া কৰিছে, আমি কেনি ওলাম। মই সেই কথাটোকে কৈ ঘৰত বিবিক বাইকখন থৈ পথাৰলৈ যাওঁ বুলি ওলাই আহোঁতে আমাৰ পদূলিত ককায়েক ভায়েক দুয়ো হাতত বেলচা আৰু ৰদ লৈ মোক একেষাৰে মাৰিয়ে পেলাওঁ বুলি কৈ আমাৰ উপায় উদ্দেশ্যেৰে মোৰ ওপৰত প্ৰহাৰ কৰে। ৰদ আৰু বেলচাৰ প্ৰহাৰত মোৰ তেজেৰে ৰাঙলী হয়। মই প্ৰাণ বচাবলৈ ঘৰলৈ পলাই যাওঁ। তেওঁলোকে মোক মাৰিবলৈ খেদি যায়। পত্নী তাতে মোক চিঞৰ-বাখৰ মোক প্ৰাণ ৰক্ষা কৰে যদিও মা আৰু পত্নীক প্ৰহাৰ কৰি মাটিত বগৰাই চিৰতা হানি কৰি সিহঁতে লৈ অহা বাইকখন সেই স্থানত এৰি তাৰ পৰা পলায়ন কৰে। Now, your lordship, what has happened in fact in this case, your lordship? We have not we have a dumper, your lordship. By using that dumper, your lordship, on the basis of certain requirement made by a contractor, your lordship, we are bringing not from the, your lordship, river bed, your lordship, from the personal land, your lordship, we have bringing, your lordship, this land, your lordship. And what they have objected to that we should not, and they are not allowing us to move the vehicle, your lordship. There is an altercation took place, your lordship. Ultimately, we went away, but he, your lordship, just to harass us, your lordship, they have come up with this FIR, your lordship. I am doing business, your lordship, with a dumper, your lordship. That is my only source of income, your lordship. And he, your lordship, is not allowing me to go through that, use that road, your lordship.
On the going by the FIR itself, only FIR,
lordship,
interim may not be justified.
Lordship.
Because he said that the blood
Yes,
was
that is
sprouting
sprouting.
out.
Lordship.
He indicates severe head injury. According to it's exaggerated.
Lordship, so far as I have not used that, your lordship. What he is saying, your lordship, I have not used that, your lordship. The belcha, etc., your lordship. These are exaggeration, your lordship, and exaggerated FIRs, your lordship, as per my instruction, your lordship. That's why I am before this honorable court, your lordship.
So I prefer case diary also.
Your lordship may call for the case diary. In the meantime, some protection. I will cooperate with the investigation, your lordship. Ultimately, this is not a case where at least custodial interrogation is required, your lordship. If altercation took place in the spur of a moment, your lordship. They themselves have admitted that they have not stopped us from moving the vehicle, your lordship.
Projected conduct did not
Lordship.
justify so much.
Lordship.
As per 482 bill application. Police board PS case number 149 of 75.
Now he is on run, your lordship, Bihu is also coming, your lordship.
Allegation in the FIR date is 15/12/2025. Is about one dumper belonging to the petitioner causing some damage to the road, and upon telling the same to them politely, later the petitioners came to his house and assaulted him, causing injuries. So Gorthakur Council submits that the petitioners are doing business with the dumper and there was an altercation. However, the version in the FIR is highly exaggerated. And he undertakes to render his cooperation to the investigation. Call for the case diary along with medical report. However, to enable the petitioner to record his version of events, it is directed that in the interim 30,000 with one suit, the satisfaction of the arresting authority, subject to the condition number one, cooperate, appear, shall not cause any harm, harassment, or annoyance to the informant victim side. But since they are also associated with some organization, responsibility is even more social responsibility.
That is there.
Because it's very problematic.
Lordship.
They can give on 29, 30 or something.
Lordship.
30, 30.
Lords.
Please. Short.
Lords.
Motion.
My lord, in this case, in one case we have filed objection. Other case, my lord, we got the copy later on. So, my lord, we pray for little accommodation to file objection.
Which one?
In one case,
AB 79,
in one case, we have filed the copy. And moreover, to my information, case is charge sheeted also. Of course, I do not know where. My lord, the case in 2664, I have to file objection. My lord. There on interim order, to my continue, my lord, let it come out of vacation. In the meantime, we will file it.
Third, as Dr. Lanet, counsel for the petitioner. RJ DP Goswami for the prosecution. SC Biswas entering appearing on behalf of the informant. Case diary is available.
I'm told it has come.
It has come.
It has come.
The informant, Mr. Biswas, Lanet counsel for the informant, seeks to file a objection in this petition. Prayer is allowed. The interim order passed on so that
in both the cases, man.
Passed on 12/11. Coercive action, some kind of 12/11/25 shall continue till the next date of listing. So stop. This the case diary will retain or send it back.
It will retain here, I think.
Case diary be retained.
Only problem, they have filed a bail application because the case diary, the trial court could not consider those petitioners.
Okay, it's stuck up here. Send it back. Here also there is interim. Yeah.
Yes.
Then there is no issue.
There are other activity also. It is a brutal murder, man.
So what is the rule of all these people that your lordship will ascertain that only?
The case diary be sent back and procured again for the next day. Similarly, in this, in the second one, you are not filing objection.
No, that we will want fine.
Won't file.
In one case we have filed. Second one we have not filed.
Oh, sir. 2608.
Well, 2664.
That you'll file.
I'll file. And in other case we have filed.
That's the informant has already filed one objection. In this case, second to the 2608. Market claim. Interim order dated 14/11. This is the matter on. This diary be returned back, procured again. Date, you can suggest the date.
Lordship is fixing any date.
No, I am seeking it from you.
Oh, yes.
Both of you. You can suggest a date, please.
Any date, my lord, as per your convenience. My lord, after Bihu, I think will be first week of February, my lord. Because we have got so many holidays, my lord. In this case, my lord, up to 22nd, there is a holiday.
30.
30. Yes, yes.
Mr. Doctor. 30. 30th January. 3. Okay.
All right.
30th January.
Much obliged.
PA 2608, my presence may kindly be recorded.
Oh.
AK 2608.
God bless you.
এটা কি নাম্বার আছে মাত্র করে
কি আছে তো in 80 my name should be recorded man
where
in 80
80.
same
PA 260.
okay
no 80 is AB only
AB yeah similar method my name
so
should
you
be recorded man yes sir.
আচ্ছা ডক্টর স্যার এইটা প্লিজ
Timing at important.
Mid-page, Your Lordship. In this anticipatory bail application, Lordship, the background history is that there was a mutual Marpit, Lordship. And after that, Lordship, this annexure 1 FIR was lost by one Rahela Begum, page 14, Lordship.
naming 5 persons right
Yes, Lordship. And out of this, the Abdul Khandan, Amiruddin, and Abdul Alimuddin are the petitioners, Lordship. Abdul Hasim, Lordship. 1, 3, and 4 are the petitioners, Lordship. And after this, Lordship, the victim died, so accordingly later on 302 was added. And annexure to our complaint case, Lordship. In this case, by the annexure 3, we have moved an anticipatory bail application, Lordship, that was granted, page 29. The above named accused persons are allowed to go on interim anticipatory bail of rupees 40,000 each with the surety of the like amount to the satisfaction of the arresting authority till receipt of the city on condition that, and thereafter, Lordship, this bail application was disposed of. Though interim word was there, last paragraph, Your Lordship will find this mispetition thus disposed of. So accordingly, we appeared, and in the progress report also it is reflected, page 30, annexure 4. Page 31, relevant portion, first paragraph, last 3 lines, Lordship. During investigation, I have received an order copy of the Honorable Court dated 25/5/23 regarding the accused persons, namely Abdul Hanan, Amiruddin, and Abdul Hasim, who are allowed to go on interim anticipatory bail with condition. And thereafter, charge sheet was filed showing absconder, Lordship. So when the trial court issued summon, Lordship, we filed an application before this court, and this court set aside the NBW, all the NBW, and passed an order to appear the petitioner before the trial court on 1911.
okay then
In 1911, we filed an adjournment petition, but that was not considered. That thereafter, this order was passed, annexure 11, page 57. Again, NBW was issued, Lordship. We want to face the trial, Lordship. Some protection may be granted and will appear accordingly. As the court is subdivisional judicial magistrate, Lordship, the case is not yet committed, Lordship. So the petitioners got an apprehension that they may be arrested as soon as they appear before the trial court, Lordship. Page 57, annexure 11, Lordship.
no High Court granted bail
No, Lordship, bail was not granted. NBW were set aside.
set aside and they were directed to appear
On 1911, we appeared, filed an adjournment petition, but that was rejected, Lordship.
right
As the High Court not granted bail against, because, Lordship, that was criminal petition. No, AB was filed, Lordship. Page 52, Your Lordship.
again NBW was issued
Yes. So I am apprehending, Lordship, so some protection may be given. The petitioners will appear on the date when Your Lordship direct, Lordship.
yes what do you say should we get the record or dispose it?
Dispose it up, giving.
Because earlier he was on interim, Lordship. Therefore, he appeared and before the IO. And
Subsequently,
NBW set aside, he has also prepared for them. Lordship can dispose it of, Lordship. And maybe Lordship can be called for a records and let him appear.
dispose it some we should dispose it
Lordship.
save time so anyway these are little serious cases but still Our Chaudhary, Learned Council and DP Goswami. Petitioners are seeking anticipatory bail under 482 BNSS in connection with Karimganj space case number 717 of 2022. In bracket PRC 1675. Under so and so 302. The three petitioners are amongst the 5 persons who are named in the FIR dated 9/12/2022. The gist of the allegations is about assault and causing of serious injuries and a subsequent death of one person died, right?
Yes, first.
The subsequent death of one person.
Informants, mother-in-law.
Investigation resulted in charge and NDWA is pending against the petitioner by the order dated 19/11/2025. Past 5, the learned SDJMS Sri Bhumi. As the relevant documents are annexed with the bail petition, I propose to dispose of this bail petition. And the same is not objected to by the learned additional people. You can say this for disposing.
Yes.
No issue. Despite the serious nature of the alleged offences, considering the fact that investigation is already completed and granting of bail at this stage might facilitate progress of the trial. Such view of the matter is directed the event on 3 petitioners, right? 40,810 each, 40,000 each. Subject to the following conditions. Number 1, they shall be available for the trial if one commences. Number 2, they shall appear before the learned court below the dates required. They shall not hamper or tamper with it. They shall not cause any harm to the witnesses or informant/victim side. They shall not misuse their liberty to commit any offences or illegal activities.
But in my humble prayer, not objecting, in spite of not objecting, I'm fairly submit that he has cooperated with the investigation, and after getting interim, my submission will be recorded in spite of not objecting.
I'll remove that. I'll remove it.
Next date is on
I'll
31,
remove that.
2026.
The learned additional PP submits that on earlier occasion after getting some interim protection, petitioners had appeared before the IO.
Yes.
So need to cut it.
Lordship.
Yes, thank you. Sorry, you said.
Next date is 31, 2026, Lordship.
Yes, yes.
On that date,
Yes, they can appear. I'm disposing of, no, problem.
Lordship.
The petition stands allowed and disposed of. Enforced.
obliged, Lordship.
Disposed of. Collect.
59.
May I continue, Lordship? Lordship, item number 59 and 47 out of same affair, Lordship, and in item number 47, CD receipt.
CD receipt, Lordship, at that, let the matter come on 47, Lordship, take it 47.
After some time.
After some time, the Kuldeep boy says, don't out the diary, Lordship. Can I get over it? That's that. 60.
Oh. 59.
59 is already 59 along with 47, Lordship.
47.
60.
Lordship, 60 along with 70, that item, Lordship.
And
Anticipated bail.
Itu case le? Aroda আছিল যে?
70. That Lordship, in civil uniform, Lordship, police has picked up that man, Lordship. This is an anticipated bail, Lordship.
Should I take up the BA first?
Yes, Lordship, that items
6.
6, Lordship. Lordship is like
CD has been received. Right?
CD not received. I made a prayer for another date.
Lordship, 70 probably, 70 case diary was called for, Lordship.
Yes, but that is not received.
Lordship, may I play, Lordship, let the 70 can be taken first, Lordship. Bail application number 5/2026, Lordship.
Two are BA, one is AB.
One is AB, that is Lordship, yes, the 70 is the BA Lordship, BA numbers 5/2026. FIR Lordship will find on page 16, Lordship. Here, what happened, Lordship? The police in civil dress, Lordship, picked up a person, Lordship, Baharul Islam. I'm not for the Baharul Islam, Lordship. Then, Lordship, he raised a crowd, he raised a halal, Lordship. Then, cricket match was going on there near the place, Lordship. People rushed to their place, Lordship. And they, Lordship, doubted about the identity of this police because they have not shown the identity card. They come on a Lordship, private vehicle, Lordship. Now, that person, Lordship, Baharul Islam, Lordship, fled away for taking that chance, Lordship. Now, police is after these villagers, Lordship, who are there, Lordship, were watching this match, Lordship. They were now, Lordship, they were asked to produce that Baharul, Lordship. How can this petitioner, Lordship, they are suspecting this police because they have not shown their identity card, Lordship. Already, Lordship, 11 days, Lordship, since Bihu is there, Lordship, case diary, Lordship. May I pray, Lordship, till, Lordship, any adverse report come against this petitioner, they may be allowed to go on interim bail, Lordship. Otherwise, they will not fled away from this place. They are local people, Lordship. All the villagers keeping a Lordship. They said they come in a civil uniform, Lordship. That is on page 16, Lordship, FIR. No, people will definitely suspect, Lordship, if they picked up a man, Lordship, and that man raised Allah, Lordship. Now, later part exaggerated, Lordship. These are,
Will be necessary.
Lordship, feel that some protection, Lordship, Lordship, because, Lordship, this view led that if any adverse come, Lordship may reject on that day, Lordship, in fixing, Lordship.
But let me hear that.
Yes, Lordship.
Yes.
Lordship, case is required, Lordship, in this case.
Because, the allegations are that, I don't know, I mean, at the moment, we have no. option
That's
but
why,
to-
Lordship, that's why, Lordship, I'm
By
praying.
the FIR, by and large, that these persons, they have linked the attack with the possible involvement of these persons also.
Lordship, the entire women and villages cannot be, Lordship, in the same time, Lordship. They are- Lordship,
10%.
that's why, Lordship, I'm seeking only, Lordship, limited period, Lordship, let the Bihu over, Lordship. In the meantime, they may be protected, Lordship, because that, Lordship, for that only allegation, Lordship, they should not, Lordship, because of that Baharul Islam, they are against the Baharul Islam. I'm
Islam
not-
escape.
Yes, Lordship, he has escaped, Lordship. He is named in the FIR accused number 1, Lordship. How they connected with this Baharul Islam? These are the local people. They said, Lordship, they are from that area, Lordship.
So immediately reopening, Lordship, will try to.
Lordship, kindly, till date, Lordship, let the enjoy the view, Lordship. Only 9 days or 10 days, Lordship. Kindly protect. If anything adverse comes, Lordship will reject my bail, Lordship. I'll not, Lordship, pray for any.
Learned Council, the state. And then, did we call for?
CDA was called for, Lordship, on last 5/1/2026. That's why, Lordship, called for CD on short date, Lordship. And item 60, the anticipatory bail, Lordship.
Frankly speaking, not a very fit case.
In the Lakhimpur area, lots of cases are there.
They try to connect it, Lordship. They try to only limited period, Lordship.
Anyway, it's okay, but not a very fit case.
Yes,
per
Lord.
se. B. Chaudhary Learned Council, DP Gosan, 483 bail application, B. Puria PS case, 44/25. Two petitions. An FIR was lodged on 28/12/2025, naming 10 persons, including women, with the allegation that on 27/12/2025, where police personnel came to arrest one Baharul Islam, within bracket, accused number 1, and in civilian clothes, and thereafter the state accused raised hue and cry, whereupon large group of persons attacked them and caused grievous injuries. And the apprehended individual was snatched away. The Chaudhary Learned Council submits that after the escape of Baharul Islam, the police put pressure on the other FIR named accused persons who are actually villagers, local villagers, who were present at that place. to produce him. And they have been falsely implicated in this case. Nevertheless, case diary was called for, however, it is not yet received. Considering the fact that the next few days are not working days in the court, in this court, it is directed that in the interim, it is the petitioners allowed to go on bail of rupees 25,000 each, the surety of the like amount each to the satisfaction of the concerned honest court, and subject to the condition that they shall not abscond and they shall cooperate with the process of law.
Highly obliged. Lordship, regarding item 6, that is a same FIR, same forwarding, Lordship.
Lordship
We have
is
to-
dispositing of. No, interim protection. Lordship.
Interim protection. Call for the issue reminder for the
Yes.
next time. So why make a difference? This also we have to give some protection.
Yes.
But I stick to that, it's not a very fit case, frankly speaking. Because the holidays are there, that's why, otherwise it's, because you have to see, at the moment, we cannot say, we cannot go by the presumption that the affair is false. We cannot start.
Not really.
It will be about 25,000 with 10 AB, lucky to AB, 60 and 70.
70 is BA, Lordship.
70 is here.
Yes.
They were arrested on 30/12/2000.
Same date.
Same day. What is BA?
Item number 60 is anticipated bail.
You're appearing, right?
Yes, Lordship.
That accused number 1 is not.
No, not.
25,000
Highly obliged.
They will record their statements.
Highly obliged.
70 BA.
BA.
Same date of arrest. 6 BA. Same date of arrest. And 60 is anticipated.
List on Lordship 28/1.
Huh?
On the February.
Give it a little early. Give it in January only.
Yes, Lordship. 20 January.
28/1.
Here, one of the petitioner is a lady.
Yes, Lordship.
Call problem, fiery problem. Date I have not.
28/1. 28/1.
Highly obliged.
The FIR your lordship will find at page 15, the allegation is that, my lord, I tried to outrage the modesty of the informant by touching her cheek, my lord, while sitting in the police station. Well, 17 is the, my lord, original FIR, if I may read, my lord.
Go ahead.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই ওপৰত উল্লেখ কৰা ঠিকনাৰ বাসিন্দা যোৱা 16/10/2025 তাৰিখে সন্ধিয়া মই আৰু মোৰ স্বামী বঙাইগাঁও থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ৰ বিশেষ ৰুমত লগ পোৱাৰ বাবে থানালৈ যাওঁ আৰু বিষয়া মহোদয়ক লগ ধৰাৰ বাবে থানাৰ জিৰণি কক্ষত বহো। সন্ধিয়া অনুমান 7:35 মান বজাত মোৰ স্বামী বহা পৰা উঠি বাহিৰলৈ যোৱা চেগতে তলত উল্লেখ কৰা আসামীজনে অসৎ উদ্দেশ্য অৱলম্বন কৰি মোৰ নিচেই কাষলৈ আহি থানাৰ কিছু সংখ্যক কৰ্মচাৰীৰ সন্মুখতে আসামীজনে মোৰ গালখন স্পৰ্শ কৰাৰ লগে লগে মই আসামীজনক কিয় এনে আচৰণ কৰিলে বুলি সোধাত আসামীজনে মোক ইমান বেয়া পাব লাগে বুলি উত্তৰ দিয়াত মই বাহিৰলৈ আহি স্বামীক সকলো কথা কওঁ। আসামীজনে এই অসৎ কাৰ্যত মোৰ মান সন্মানত ব্যাঘাত হোৱাৰ উপৰিও আসামীজনে মোৰ শালীনতাত আঘাত হানিছে। This is the only allegation, my lord. Well, the fact of the matter is that, my lord, the FIR is lodged after 10 days, 10 to 12 days from the date of incident, alleged incident. And I also, my lord, I have a CRPF personnel. I visited the police station on that very fateful day, my lord. I met her since, my lord, she was known to me. I tried to, my lord, greet her, my lord, and she became furious. My lord, changed my lord, way. Then after 12 days, my lord, she lost this FIR, my lord. Her husband is also a police personnel in the same police station. I was on leave. For some official purpose, I visited the police station. There I met her. I tried to greet her, being known to me, my lord, since childhood. And I don't know, my lord, what is the purpose behind this. After 12 days, she lost this FIR, my lord.
He is a CRPF personnel.
CRPF personnel, my lord. Perhaps the, my lord, the mindset would be, my lord, if I am arrested, 48 hours custody, man, I will be suspended automatically.
Projected conduct is not good.
Not good.
Not good. Inside a police station.
Inside a police station.
Dangerous. Nowadays, CCTV is also there. And police personnel. And of course, I mean, see, for a child, it may be innocuous. You're not even allowed to touch a child like that, but here it
Yes,
will be
44
considered
years
offensive if you just, but adult, unless someone is a very close friend or something, that's not be a proper conduct. May not be exactly outraging or modesty, but may not be improper conduct.
In a police station, yes.
Because in this kind of things, it may be even sexual harassment, because these principles of these things is that the person may think it is it's a friendly gesture, but most important thing is that how does the alleged victim perceive it? This is what I've learned
Yes.
from the various seminars and all these things, that how the victim perceives that act as an uncomfortable advance, then that will not be proper.
Yes, that's
Not test is that actually. Test is that.
In fact, my lord, she is my friend, known to me since childhood. I did not even touch, my lord. I just went there to greet her, seeing her after a long time. I don't know why she got furious after 12 days, and the explanation is also very absurd in the FIR. Why there was a delay in lodging the FIR. I'm not only delay part, but the allegations, my lord, is simply, my lord.
There were other people also, no, actually. So anyway, so heard so and so. 482 bail application, Bongaigaon PS case number 274 of 2025. The informant lodged the FIR on so and so date with the allegation that on 16/10/25 she had gone to her husband is a police
officer.
Went to the Bongaigaon PS for some work, and we're waiting in the other room. And when her husband went out, the accused came and touched her cheek, due to which she felt bad. And thought that she had insulted her modesty. The petitioner claims that the informant victim is known to him, and that he had not. It was a friendly gesture, and he had not intended to offend the petitioner. What do you say on the entry? I'm slightly. I have to.
I prefer victim statement is required in this. And at least we have to.
I'll cooperate. I am already on leave, my lord. I am posted now in
Because two
Manipur.
things are, he himself is a police person, uniform person, and it happened inside a police station. As such, many people have safety concerns inside police station, unfortunately. That's why also the CC camera. Can you fix it on 19? Not sure. Put it on 19. Call for the case diary from the concerned police station. The learned petitioner counsel seeks to praise for interim protection. I've given my anxious consideration to the said prayer. The projected conduct in the FIR is definitely bad, as the alleged incident took place inside a police station, and the petitioner is himself stated to you a member of CRPF. However, I have also given my consideration to the projections made on behalf of the petitioner side. Therefore, despite the aforesaid observations, the petitioner should be asked to record his version of events before the investigating officer. And thereafter, a final view on this bail petition can be taken. In such view of the matter, 30,000 with 1 unit, the satisfaction of the concerned arresting authority, and subject to the condition that he shall cooperate with the investigation, appear before I for recording a statement. Number 3, shall not harm or cause any annoyance or harassment to the informant / victim. List on, fix it on 27. 27.
Much obliged.
62.
May I please know? For a application, my lord, and FIR page 9, my lord. And in this case, what happened, my lord? There is a, my lord, civil dispute is between the, my lord, informant and, my lord, the accused number 1, the Bazaar committee, my lord. Yes, and, my lord, in that Bazaar, my lord, we have purchased one, my lord, shop, my lord. So, my lord, some interaction took place, my lord, and the FIR was lost, my lord. One person has already been arrested, my lord. Son of petition number 6, my lord. So, my lord, civil case is there, it is mentioned in the FIR itself, my lord, page 10. Since 2018, my lord. Actually, my lord, civil dispute, my lord. The case diary may be called for. In the meantime, my lord, we may be protected because our statements are required.
What exactly happened?
My lord, exactly, my lord.
You want to read?
Allegation, my lord, page 10, last para, my lord.
Well, let me read it myself.
My lord.
Civil case is pending.
Yes, my lord. Broke 2 teeth of front side.
Huh?
Broke 2 teeth of front side in the right side of my face.
Yes, where?
It is the last part, 11, page 11.
All right, this person. Medical report would be necessary.
Yes, necessary, but my lord, no such serious injury, my lord. So it will
go for PS 402 of 2025. As many as 9 persons are named in the FIR dated 27/12/25. It's clear from the FIR that there is some dispute over property between the parties, for which a civil case has also been filed, and civil case is pending before the learned civil court. Full stop. Connection with the same, the informant has alleged an assault and causing of injuries. The petitioner counsel submits that there's no such grievous injury and that the narration is exaggerated. Call for the case diary along with medical report. However, in the interim, the petitioners 20,000, 25,000 will appear.
Yeah.
And record their statements and not cause any harm and harassment to the informant side. Miss the matter.
A matter is fixed on same PS, my lord. Same PS case. Same PS, my lord, 22. Another matter is fixed on
Another
in same
matter is
PS case on 22nd. Let the matter.
22 once.
I love it.
Made to the law.
Oh, no.
For anticipatory bail application, my lord. FIR is at page number 19.
Just a minute. Page.
Page 19, madam. May I read the FIR, madam?
Go on.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ছোৱালী ৰায়হানা বেগম বয়স 17 বছৰ আলবাত স্বদেশী একাডেমী ধৰ্মশালা HS ফাৰ্ষ্ট ইয়াৰত পঢ়ি থকা ছাত্ৰী কিছুদিন আগৰ পৰা 1 নম্বৰ পদকীয়াই মোৰ ছোৱালীক প্ৰেম প্ৰস্তাৱ দিয়ে ছোৱালীজনীয়ে তাইৰ মাকক অৱগত কৰে আমি 1 নম্বৰ পদকীয়া দেউতাক ঘটনাটো জনাও যদিও তেওঁ পিছৰ বিয়াৰ প্ৰস্তাৱ দিয়ে কিন্তু ছোৱালীজনীৰ বয়স নোহোৱাৰ বাবে মই মানা কৰি দিওঁ so our father refused the marriage matter যোৱা 20/11/2025 তাৰিখে 2 নম্বৰ পদকীয়াই মোৰ ছোৱালীৰ লগৰ স্কুলৰ সন্মুখৰ লগ কৰি তাই বজাৰত লৈ যায় আৰু পিছত বজাৰৰ পৰা ই-ৰিক্সাৰে ঘৰত পঠাই দিয়ে ঘৰত আগদিনাৰ দৰে তাই নিজৰ কোঠাত টোপনি যোৱাৰ কথা কৈ দৰ্জা বন্ধ কৰি দিয়ে সন্ধিয়া প্ৰায় 5টামান বজাত 2 নম্বৰ পদকীয়াই আমাৰ ঘৰত আহি ছোৱালীজনী ক'ত আছে আৰু আমি মাতি দিবলৈ কয় তেতিয়া ঘৰৰ মানুহে মাত দিয়া দৰ্জা নুখুলাৰ বাবে খিৰিকী ভাঙি দেখা যায় পাই যে ছোৱালীজনী চিপজৰি লৈছে পিছত দৰ্জা ভাঙি ঘৰত সোমোৱাৰ লগে লগে 2 নম্বৰ পদকীয়াই ছোৱালীৰ লগত থকা মোবাইল ফোন আৰু আন এটা মোবাইল লৈ লগালগ ঘটনাস্থলীৰ পৰা পলায়ন কৰে accused number 2 is the mother of the accused number 1 প্ৰকাশ থাকে যে ঘটনাৰ
Can you repeat that? ঘৰত সোমোৱাৰ লগে লগে
ঘৰ সোমোৱাৰ লগে লগে 2 নম্বৰ পদকীয়াই ছোৱালীৰ লগত থকা মোবাইল ফোনটো আৰু আন এটা মোবাইল লগালগে ঘটনাস্থলীৰ পৰা পলায়ন কৰে So as per this FIR, the mother of the accused number 1 took away the mobile phone, 2 mobile phones. প্ৰকাশ থাকে যে ঘটনাৰ পিছত ছোৱালীজনীৰ পঢ়া টেবুলৰ পৰা কেইখনমান আপত্তিজনক চিঠি উদ্ধাৰ হয় so this FIR was registered under 10835 of the BNS abatement of suicide but to be an offense of abatement of suicide there must be some role of the accused first thing is that there must be mens rea second thing is that the accused by their acts must drive the victim to such a situation where the victim has no other option but to commit suicide but here my lord apart from only one negative thing that was the refusal of marriage was not refused by the petitioners it was refused by her own parents other than that there is no role attributed to the accused as such for which the victim might have committed suicide nothing is there there must be some active role on the part of the accused the petitioners just because her marriage was refused perhaps she feel rejected and perhaps she might have taken that decision other than that from the FIR itself there appears nothing on behalf of the accused
Prima facie, there are material, so the perusal of the case there is necessary,
that will be necessary
it will reveal everything.
So many people committing suicide for silly things. S. Das and RJ Bora, 482 bail application. Here, Rashida, she is the mother.
Nozrul Islam Bepari, as Rashida is the mother, accused number.
And the boy is
Mustafa Ahmed.
Is petitioner number 1. And petitioner number 3 is father. Petitioner number 1 and his parents, being the other 2 petitioners, are seeking clearance with invoking 482 in connection with Dhubri PS case number 446 of 24. On is alleged in the FIR dated 22/11 that on 20/11/2025, the informant's daughter was found to have committed suicide. It is stated that there was a love proposal from the side of the petitioner number 1, and but it was rejected by the informant's family due to her age. And on the day of the incident, his daughter had gone with, had met the petitioner number 2 in the market, and after that came back home. Subsequently, the tragedy happened. Incident happened. Mr. Das, learned counsel for the petitioner, questions as to whether the allegations made so far make out any offense of abatement of consent. Nevertheless, call for the case diary. However, in the interim, 40,000 with one.
Highly obliged, man. Highly obliged.
Before the state, usual conditions.
Date, my lord,
Date you- I
31.
have not given you.
31 or first week of February.
February.
Stick of
First
February.
4/1, 4/2, my lord.
Highly obliged.
May it please your lordship, a 482 bail application, lordship. The petitioner is a student of Downtown University, lordship. This is a non-FIR case, lordship. What has happened, lordship, on 1st of January, lordship, a accident occurred near the vicinity of the petitioner's house, lordship. Thereafter, the petitioner, the police has been repeatedly calling him to appear before the North Lakhimpur police station, lordship. But till then, no notices has been issued to the petitioner, lordship, nor any intimation with regard
An
to
accident took place near his house.
lordship, that much, lordship.
The borderline.
Lordship.
Borderline and. Yes. We call for a report.
We'll call for the report, my lord.
Lordship, till then, no coercive action, lordship.
Petitioner is invoking 482. BNSS, however, they does not have details about any case being registered against him. However, it is stated that on, do you know the date or
Yes, lordship, I have stated in my
that
petition, lordship,
it is
1st of January, lordship.
that it is stated that, oh, maybe some incident of drunken driving or someone.
Lordship.
It is stated that the petitioner was a university student. Sorry, down. It is stated that there was an accident on 1st January near the house of the petitioner,
Lordship,
who also happens to be a university student,
lordship.
and the police has been calling him. A notice has been given?
No, lordship.
No notice have also not been given. Call for a report from the concerned police station. Till the returnable date, the petitioner shall not be subjected to any coercive measure, coercive action, subject to the condition that he shall cooperate with
Lordship,
the police for any investigation
lordship,
or / inquiry.
lordship.
List on.
My lord, 2/2, my lord.
2/2.
Lordship.
Oblige, your lordship.
May it please your lordship, 65 may be taken after sometime, my lord, or actually.
May it please, my lord. 90 days since the FIR has been lodged, my lord, no CD has been given, no charge sheet, my lord. I'm entitled to absolute bail, my lord. Already this honorable court has granted me the privilege of interim bail, wide order dated 24/11/25, my lord. Today is exactly 90 days, my lord.
You'll get the right tomorrow, but we can pass an order. But if we pass it today, it will not be compulsive bail.
My lord.
The statutory bail can be passed only on the next day, 91st.
Day, my lord.
The 90 days will be over, but we can, you take instructions.
We'll take instruction, my lord,
My lord,
regarding.
date of reopening then, my lord.
No, in the meantime, it will be over. In the meantime, it will be over. Date of reopening,
Kindly, my lord.
what happened actually?
My lord, allegations of gang rape against us. My
Oh.
lord, one of the applicant is a physically disabled person.
Allegations of
Actually,
serious-
my lord, the entire episode arises out of a monetary dispute, my lord.
Mhm.
Actually, what had happened, my lord, the husband of the Ejaharkari,
Mhm.
he had borrowed some amount from us, my lord, 1 lakh rupees from both the applicants, my lord. Then he could not repay, my lord. And in fact, if my lord has page 13 for a moment, if I may kindly demonstrate, my lord.
13.
13, 1/3/13, that is the
Yes, I've read.
Yes, my
I've gone
lord,
through.
that is the case, my lord. They say that they had taken the matter before the Gao Panchayat. Now, my lord, for a grave offense such as heinous and grave offense such as gang rape, my lord,
That's gang rape.
they are gang rape. Fifth, they say that fifth the incident occurred. Why did they wait till 12th, my lord? Say 1 week, my lord.
So 7 days.
7 days, my lord.
Let us
It's a
take
big
instruction, my
lacuna,
lord.
my lord.
Let us take instruction, my lord, whether investigation
My
is
lord.
completed or, my lord, if investigation is completed, search is submitted, my lord, then question of default bail does not come, my lord.
Okay.
Only in case of, my lord, pendency of the investigation, my lord, then only, my lord.
Then tomorrow you will be entitled to.
Yes, default bail, my lord.
Anyway, tomorrow is a holiday. District courts are reopening on 6th, I think. Anyway, you take the instruction.
We'll take
That
that.
will best.
Yes.
Take the instruction after something.
I am deeply obliged.
After something.
Time being 65.
65.
Made to your lordship. Here, your lordship, FIR, your lordship will find at page 9. The petitioner is not named in the FIR, lordship. Your main allegation that FIR name accused persons took JCB from the informant, lordship, and subsequently they did not return that JCB, and accordingly FIR was lost. And present apprehension of the present petitioner is that, lordship, that he was hired by the accused persons to drive the vehicle from Nagaon to Dimapur. And he accordingly drive the vehicle on, lordship, payment of 2,000 rupees.
The JCB.
JCB. And accordingly, he lordship returned to his house because he was hired. He was not involved with that person's, lordship. And he is ready and willing to disclose everything to the investigating officer, but only because of that non-bailable section he is apprehending, lordship. Otherwise, he is not named in the FIR, specific allegation against that FIR name accused persons, lordship. And the FIR name accused persons are already arrested, lordship.
Yeah, Ahmed. Jagi Road, page 267 of 25. It is submitted that the petitioner, present petitioner is not named in the FIR dated 10/11/2025, which alleges about the accused persons named therein taking away a JCB and stuff. The petitioner, Mr. Ahmed, learned counsel submits that he submits that the petitioner is a mere driver and he had driven the JCB on hire. He was hired by the. He was hired to drive the JCB for a short distance. It is submitted that he shall that if given an opportunity, he shall reveal the details before the IO. Call for the case diary in the accepting the said prayer of the petitioner side. Directed that 25,000 it comes.
6-2, my lord. CD 6-2.
Obliged, lordship.
May I please, your lordship?
Just a minute. Sudo. Go ahead.
Das scan
Scan. Like a short cycle. Take it up. Looking for nice. I think like okay, Mr. Boras.
My lord, this petitioner is last 3 months more than 4 months in custody, my lord, in a commercial quantity case, my lord. Though he was not, nothing was recovered from his possession, my lord, and he was arrested after 3 months of the alleged recovery from 2 other persons, my lord. Now, lordship will find the FIR was lodged at 25/5/25, my lord. That is in page 19 of my petition. 2 persons has been apprehended. One is Johorul and one is Jainul. Then subsequently, one more person also been arrested, my lord. His name is Abul Hassan. 3 persons has been arrested. And after 3 months of the investigation, I was also arrested, allegedly on the basis of the co-accused statement. That is only material against me, my lord. Then thereafter, my lord, charge sheet has been filed. And during my allegation during the initial stage that there was some phone call between me and Said Jahrul, my lord. Now, lordship kindly turn to page 42. That is the bail order, and there is a phone. Abul Hassan. He was an constable, my lord, police constable. He was granted bail, considering the material that only co-accused statement. Apart from there's nothing against him in page 44, paragraph 7.
Yes, I've gone through.
Yes, so he was already granted bail. An allegation is that there's a phone call again between me and this particular accused who has already been granted bail. And the allegation is that against him also, only the co-accused statement matter. And Lordship knows that there are few judgments that the co-accused statement during the bail that cannot be taken into account when the person is in custody. Had it been a case of 430, my lord, the 483, my lord, pre-arrest bail, the matter would have been different, my lord. But this is a case, my lord, where the co-accused statement cannot be taken into account.
So it can be taken into account provided there's other materials.
Provided there is a corroborative material. my lord. Here is the corroborative material, my lord. I have also placed all the material 161 statement of all the witnesses. The no whisper against me. And the
Other witnesses.
other witnesses, there is no whisper against me. And the allegation, my lord, the search sheet, there is no whisper against me regarding the phone call. In the search sheet also, they have not relied that initial statement, there is a phone call. And as far as the CDR goes, the CDR shows there is a phone call between me and the accused, my lord, who was granted bail, my lord.
He was arrested on
I was arrested on
8/9.
8/9/2025, my lord. And the case was registered on 25/5/2025. After 3 months of the incident, my lord, I have been picked up. And coincidentally, my lord, I happens to be the president of the Gaon Panchayat, ma'am.
Oh.
I happens to be the president of the Gaon Panchayat. And obviously, there are phone call between that constable and me because of the various
One of
reasons.
the accused is a constable.
He was granted bail and he is
Constable.
He is a constable, he was granted bail, considering that only co-accused statement. And CDR report says, as far as my instruction, my lord, there's a few telephonic exchange between these accused and the desk constable. And I being the Gram Panchayat president, there has to be, my lord, there can be a telephonic exchange, my lord, for various reasons. And they have not relied on that CDR in the search sheet, my lord. Specifically, I have annexed the search sheet, not a whisper against me in the search sheet, how I have been implicated. Only the co-accused statement. Apart from, my lord, I have annexed all the statement of the witnesses, my lord. No whisper against me, my lord. And there is no whisper against me. Lordship knows what will be the fate of the trial in this case against me, my lord. So, my lord, my prayer, I'll appear each and every date in the trial, my lord. I already on the last 4 months I have been in custody. Co-accused has been released on the bail on the same ground.
So let's straight go to that aspect.
Yes, no, my lord, my humble
Lord,
submission, my lord. I'll just take your lordship to page number 38, my lord.
The other day we had discussed this aspect, no? That CDR, only CDR calls is not enough. The contents of the calls are
Yes, my
also
lord, that
very
is,
important.
that is why,
very
my lord.
necessary. What communication to in today's times, everyone has a mobile phone in his or hand. So there can be calls, but what is the it is the content, if the content is incriminating, that can nail the person, suppose, from the point of view of the prosecution.
Now, my lord, this is a case of conspiracy, my lord. Apart from the, my lord, the NDPS case, my lord, conspiracy is one of the matter, my lord, which has to be taken into consideration,
29.
my lord. Now, my lord, to prove a conspiracy, my lord, there cannot be any direct evidence, my lord. So my learned friend
Not
is
easy to
submitted.
get direct evidence.
No, cannot be, my lord. Now my learned friend is submitted, my lord. There is no whisper against this accused petitioner, my lord, in the 161 statement. Now, my lord, my humble submission is, my lord, who are the 161 witnesses whose statement recorded under section 161? There will be, my lord, Caesar witnesses, my lord. There will be, my lord, FSL, who examined the, my lord, the contraband, my lord, whether it is a positive or negative, my lord. Other witnesses, my lord, they cannot prove, my lord, whether this person is, my lord,
So
involved or
witness
not, my
will
lord.
prove the
No,
conspiracy.
my lord, no, my lord, let me submit, my lord. Now, my lord, for this purpose, my lord, the accused person, my lord, from whose position, my lord, this contraband was recovered, my lord, they were interrogated, my lord, because they were just peddler, my lord. This accused person, and the important thing is that one police person, my lord, he is involved, my lord. They
Not
are the, my
granted
lord,
bail,
they
he
are
is
the
granted
contractor, my lord. Maybe, my lord, he is granted bail, my lord, that is a different aspect of the matter, my lord. But, my lord, what their role, my lord, in the case of conspiracy, my lord. Their role is that, my lord, they organize the customer, my lord. These accused person, my lord, whose possession, my lord, the contraband recovered, my lord, they are only the peddlers, my lord. They were asked to, my lord, collect the contraband and to deliver it, my lord. Now, my lord, since it is a, my lord, case, my lord, where is a conspiracy is involved, my lord. So, on the last occasion, Lordship has, my lord, directed, if Lordship perused the last order, my lord, Lordship has said that whether from the CDR, my lord. Can the CDR prove, my lord?
No,
that
contents can.
the contents can, my lord. 4 days, my lord, Lordship may kindly peruse.
Come across.
Yes, 4 days, my lord, Lordship may kindly peruse page number 38, my lord.
Contents
I have
can,
also,
because see, the thing is, I understand. Sometimes this kind of, position can sometimes, I understand this thing, it can be little frustrating sometimes for the
no,
investigating
there
officer
cannot
and
be, my lord,
prosecution.
there cannot be,
That is
except,
the
my
law.
lord, except, my lord.
Either the law has to be changed, just, subject to, I may be
Tufan
wrong,
Singh is,
I may be wrong.
Tufan
but
Singh
the
is,
thing
I am
that
not going against the
my
Tufan Singh, my
humble
lord.
opinion is that either the legal position has to change or the positive side is that the investigation approach has to be a little different.
My lord, they
Then you have
cannot,
to look
they
for
cannot, my
people
lord.
to whom the drugs have been sold.
No, because
Their
they cannot,
statements
my
have to
lord.
be brought in.
Because, my lord, investigating officer cannot bring any, my lord, positive evidence, my lord, in case of conspiracy, my lord.
So
Because,
that
my lord,
means I have to
that
be in
is
the
why, my lord,
custody.
the CDR was analysis, my lord, and that is, my lord, in the record, my lord, scanned to the
Yes, I
record.
have admitted, my lord, the CDR between me and the person who has been granted bail. And you have not relied on in the charge sheet regarding why the CDR.
No, you need not bother prosecution in this. All you let us see that apart from his statement, his statement and the his self-incriminating statement, suppose,
My lord,
and the incriminating statements of co-accused.
my lord,
Let us leave aside this.
my lord.
Keep it on the side.
Yes.
Apart from that, what are the materials? We should
Then
focus
Lordship
on
will,
that.
Lordship may
Just-
kindly come to page number 38, my lord. If Lordship satisfied, my lord, is up to the honorable court, my lord.
No,
Page
that's
number
okay,
38, my
that's
lord.
okay. I
Yes, my lord.
appreciate your
Page number 38, my lord, paragraph number 7, my lord.
Scan copy or petition?
My lord, Lordship may peruse the scan copy, my lord. It is more brighter, my lord. Then the, my lord, my learned friend is annexed
No,
to the
okay, no, so
petition, my lord.
38.
No, not 38, my lord. I have just, my lord, flagged it, my lord. This is a part of the search sheet, my lord.
Or from his, we can see
No,
38.
Lordship may directly see from the petition.
38.
My lord, yes.
No, I can read this.
Page number 38, my lord.
Yes.
My lord, during investigation, CDR requisitions were sent for the mobile numbers of the accused person, my lord. These are the accused person, my lord. Now, their mobile phone number also, my lord, mentioned in the, my lord, search sheet, my lord. Now, my lord, frequent communication was observed between Zohrul Haq and Abul Hussein on 25/5/2025 prior to the interception of the vehicle and seizure of drugs, my lord. This is one of the aspect, my lord. Secondly, my lord, Abul Hussein also had regular contact with Semim Ahmed, that is the petitioner, my lord. Abul Hussein is a police officer, my lord.
So he was granted bail,
My lord, who contact the customer,
First,
my
you
lord.
come to the case, my lord, when he was granted bail. Why you are not saying that?
My lord, thereafter, my lord, let me complete my. Thereafter, my lord, the CDR data corroborates the statement of the accused Zohrul and Joinul Haq, thereby establishing a network between Abul Hussein and Semim Ahmed in the drug trade. On 25/5/2025, prior to the interception of the vehicle and the seizure of drugs, Semim Ahmed Tapadar and Abul Hussein were in frequent communication, my lord. This is the prima facie materials, my lord, collected by the IO, for which, my lord, the accused person was arrested, my lord, and submitted search. My lord, the Lordship may have to see, my lord, this is a case, my lord, of, my lord, relating to NDPS matter, my lord. It is not a murder or, my lord, something stolen, my lord, other matter, my lord.
Just
So in
what-
NDPS matter, my lord, it is very difficult. Lordship will not find any direct evidence, my lord.
That's true. That's why I'm saying. I understand, if this is the position of law, sometimes it can, this is sometimes the investigation like this can be frustrating for the IO and for the prosecution. But as I said, this, everything evolves. This positional law has to evolve further, or investigation strategy has to change. Maybe using technology, maybe using something else. So this is the thing.
Now, my
Otherwise,
lord, secondly, my lord,
in any case, never forget in any criminal case that, bail is not the end of the matter.
yes, my lord.
Trial is the main thing.
Yes, secondly, my lord, this is a bail application, but this is not a quashing petition. Neither my learned friend is challenged, my lord. My lord challenges search sheet and then my lord.
Why should
FIR,
I
my lord.
challenge the search sheet?
Now, my lord, the question is that, my lord, what lordship will look into at this moment, my lord? Lordship cannot done, my lord, a mini trial, my lord.
To pass the test of 37.
Yes, my lord.
First I have to pass the test of 37.
37, my lord.
And if I do not pass the test of 37,
Yes.
matter ends there.
Yes, matter ends
If I
there.
pass the test of 37, then
Yes.
I have to see whether whether the other
Yes.
factors justify grant of bail or do
Absolutely,
not
ma'am.
justify.
Yes, ma'am. The rigor of
I know,
35.
subject to correction, I
Yes,
think
yes, rigor
I
of
have to go like
35,
this.
rigor of 37 is always there, my lord. So, my lord, considering the rigor of 37, bail was granted to a police constable by this honorable court, considering the material. At that time, what they are sleeping? This person, the same prosecution was sleeping when there is a rigor of 37. And now they are coming with me that they are saying that this is a conspiracy.
No,
For
don't-
the proving the conspiracy,
No,
lordship
it's
is
hard
correct.
for- hard
My lord.
Just stick to the.
No, man, this is, we can't, my lord, because the reason is that the one person, you will grant a bail to a person where there is a communication
No,
is
that will
there.
be failure of court. If there's a difference of,
No,
same
no.
facts, if different approach is there, that will be a failure of this side.
Okay, yes, my lord, they cannot. So I am saying the court has already gone through that path. Considering, I'm not saying that the court was wrong. I am saying court has already considered that material. And rigor of 37 has been crossed by the court. Now, how they can say that the court was wrong? Can they say, my lord?
No,
Can they say
I'm not
that
saying
then what you are
This is the
arguing, my lord?
discussion,
What
this
he
is
is arguing? That the rigor of 37,
No, no,
he is
it's
saying
okay.
on the CDR.
Court can always be wrong, but then
No.
it has to be the
It
remedy
is
against
superior
that
court has to say, my lord.
seek
We can't
interpretation.
say. My lord, subject to correction, my lord, the superior court now can say that this is a wrong order. But this court, neither I can say
We
that
can
the,
say it academically, but we cannot say it practically.
no,
If I
that's
say it
true.
practically, I go up.
So, my
I
lord,
sail the order.
so we'll go by the law.
But
We'll not-
anyway, he's not actually arguing that. He's saying that these are the
No, CDR has.
I am
no,
relying
we
on
can't
prima
say.
facie materials, my lord.
No, how can
Sir, with the
rely?
FIR as well as the
My
success, my
contention is the,
unnecessarily, making the situation agitated. All
No, no,
he's
my
saying-
lord.
all he's saying that this approach should be taken, that there are other materials also. That is what he's saying.
No, my lord, the 7, when the 7 is specific. This is a CDR report, logically see.
Yes,
The
yes, I've seen-
statement of the co-accused,
I've
the
seen.
message retrieved from the cell phone of the petitioner are also not very clear whether was a contraband. So CDR report considered in case of the person, the constable who is he's saying that the police constable, he is involved in the case in the conspiracy, and the conspiracy he was granted bail, the police constable whose CDR report is there. So court has considered that CDR report and granted bail to that person.
Okay. That you are
That's
arguing-
why I'm saying.
No, that
And
is-
apart from lordship is correct. And little bit of I have the knowledge regarding the trial. The little bit of knowledge I have that there has to be some positive statement regarding the CDR report that this is the phone call of so and so, this is the phone call of so and so, and it was made during the so and so period. Where is that statement in the 161 statement?
Phone call again, contents of
My
the
lord,
phone
these are the
call.
matter of,
First
my
of
lord.
all,
The
I'm-
IO will be interrogated, my lord.
No,
Will
no.
prove everything,
So,
my lord.
so this is what I am saying. This is the agony of mind that our High Court has categorically in a few judgments said you cannot put somebody in the perception of anticipatory evidence that tomorrow IO will prove it. That's not the law. Law is the whatever material today, on the basis of that case has to be decided on the merit. He is saying that tomorrow IO will come and he will prove the case, which is not on material.
He's saying that.
He's saying that right now. He said that.
He's not saying unnecessary.
No, my lord, my
The thing
learned
is that
friend
these
has
are-
misunderstood
See,
the submission.
So maybe I'm pouring
if you
language of
see
understanding, my
see
lord.
the thing
What
is
I
that-
have
see
learned,
the-
my lord.
See, the thing is that if you If the prosecution thinks sometimes that principles like this, which have been laid in Tufan Singh, are causing, problems in prosecution of serious crimes like drugs, this has to be, they have to seek reference to a larger bench. Law is evolving.
Already that has
See,
been done.
the thing is that these are very, very serious offenses. I'm telling you, I'm making an observation. These are very, very serious offenses. Ideally on technical grounds, one should not get away. But the thing is that the investigation has to become smarter. See, the thing is that even if you get contents, I have been told by NIA investigators, even if you get contents and the phone calls are by WhatsApp, all you find is that like this.
Yes.
That means conversation is there, but contents are encrypted, because that is the assurance of WhatsApp. So tomorrow there will be even more private, conversations. So there is always a tussle between, the investigative technology and the technology used by, alleged persons involved in crime. So this will continue. But as on today, this is the law. So, because see, the thing is that why, earlier occasion also we had mentioned this, we had observed this, that the basic principle of what has been said in Tufan Singh, actually it is there in the Evidence Act only, accomplice evidence. Why? Because the thing is that the co-accused, why someone cannot be, suppose I am accused in a case, on my statement, a person, it will be very risky to convict a person, because my credibility as a witness is very less. Since I am myself a co-accused, my credibility as a witness is very less, and therefore corroboration is necessary. It has come from that, in my humble understanding. Anyway,
That's the law, my lord. The simple as that.
So, but the thing
It will go both the ways, my lord.
But
as the person, he cannot be convicted. Pre-trial conviction is not necessary, my lord. That's also, and he is presumed to be innocent unless he proved guilty. That's the law, my lord. Here, lordship kindly knows it very well. Only the CDR report, which they have not relied in the charge sheet, not in a mention. They have CDR report simply forwarded to the court. And there's no whisper at all. As he's saying that it will be proved by the IO, and who will prove the conspiracy? My humble submission is that there has to be some statement that this phone belongs to so-and-so by some officials of the service provided, and this phone on so-and-so between so-and-so in this day. That's not there.
The calls around the time of the incident raises suspicions.
Yes,
but
only
they
suspicion.
may not be
My lord, no.
It raises strong suspicions.
To my humble submission, my lord, this is also not correct, because there may be several other calls, my lord. So
Yes.
all the persons
No,
should
no,
be, my lord, called for investigation. my lord.
No. The thing
Only
is
my
that
the person
you have a
who were,
statement
my
of
lord,
co-accused. You have a statement of co-accused.
Yes.
And then around with the said person, around the time of the incident, there are several calls. It raises a needle of suspicion.
Yes.
But it may not be enough.
What the
maybe.
investigating officer will do, my lord, only after, my lord, after
Yeah,
recording the accused person's statement, my lord, from whose the contraband recovered, my lord, whether investigating officer will examine and see, my lord, who are the other person with whom they, my lord, with whom the accused person has, my lord, interacted or had some conversation, my lord, as mentioned by them, my lord. If they had not mentioned, my lord, there may be someone, there may be various person, my lord.
Only because of the phone call and the person who has granted bail already decided by this court, my lord, how we can overcome right now the paragraph 7, my lord. He has to first overcome that paragraph 7. That apart from the phone call material.
Bail, I've seen this thing. Ideally, I've already said, ideally one FIR, one bench, it's better actually. But the thing is that
No,
different
this
orders
bench,
come.
that particular bench
different,
cannot.
orders
no,
come. I've seen.
no. That,
Principle, I cannot depart. I have to refer to seek a reference.
Yes.
If the principle is laid down. But if in orders, I've seen different orders, it causes some problems for the
No,
council.
this
folks.
bench,
I
that bench,
understand this thing.
because of some reasons, she
But
cannot
you
take
can,
up.
always submit, that which you have submitted.
No.
That I should also be treated in a similar manner as the other benches done. That
So
will get-
my only that they have to first overcome that apart from these material, which is the against co-accused has granted, there's more material against me.
So,
Then
but
I
he-
can understand.
But he's also at liberty to argue that this approach here should be different because principle has not been laid down.
Yes,
right?
man.
But anyway, these are
And
the
the
things.
second judgment, as his lordship session, apart from the Tufan Singh, that has been distinguished by the other second judgment, which I have placed before your lordship, that the Tufan Singh casement, only it is a 438 and 439. That has been distinguished in paragraph 9. That in a paragraph 8, that the Tufan Singh is still valid in case of a person when he is in custody.
Yes.
That is the second part. So Tufan Singh, that has been again reaffirmed by the Superior Courts itself.
So law will evolve only when somebody takes up a dispute. Bail is granted in these kind of cases. Someone takes up the dispute. That is the positive side of litigation, no? That is how law
Similarly,
works.
Tufan Singh said, my lord, the
Sir,
person
just-
cannot be convicted on the basis of co-equal statement. Thereafter, my lord, Tufan Singh has already been more clarified, my lord. It can be considered at the stage of bail also, my lord.
Yes.
But what are the materials?
can
my
be
lord,
considered,
honorable
but,
court will look into?
Not in the case of 430A.
No, it can be considered, but still, so far I have not come across any judgment which says that if the only material is the statement of co-accused, automatically you'll be entitled to bail.
Yes.
That has not been said.
Yes.
But the 37 interpretation can be like that, that if he cannot be convicted on the basis of this material
Yes.
after charge sheet,
Yes.
then in a way it can be, it amounts to saying that he's not guilty. 37.
Yes,
this
yes. That is my,
that is how
that is
you
my
can look at
argument.
it. That is how you can look at it also.
And
Or
secondly,
you
my
can,
lord,
then you have to say that because at the stage of middle investigation, maybe it may have another argument. But when investigation is completed, then you have to say, if you say that 37 is not passed, then you have to say that, well, after completion of investigation also, the only material is a statement of a co-accused. Therefore, if in subsequent investigation or in the trial something emerges, then he can still be guilty. Therefore, 37 is not passed. That will be another kind of roundabout logic. But straight
But
logic
the, on
would
the
be this.
basis of the anticipatory evidence at this stage, my lord,
Straight logic would be this.
hypothetical situation
Yes,
that
that would be,
tomorrow in the trial some material will come.
That is a
May not be also
speculative logic.
speculative law.
but
That's
Lordship,
that
but Lordship also cannot come into a conclusion, my lord, that there is absolutely no materials, my lord. Why, if Lordship allows this bail application also, my lord, that also cannot be, my lord. Because, my lord, the investigation, this is a case, my lord, where investigating officer has submitted a search sheet, my lord.
material, my lord.
Remember the expression. There are reasonable grounds to believe that he
Yes.
is not guilty.
Yes.
Reasonable grounds.
Reasonable.
Otherwise, if you say that he is not guilty, why conduct trial? Acquitted at this stage only.
He will be discharged, my lord.
Reasonable,
Discharged.
only the reasonable. At this stage, reasonableness only.
Chamber.
Pronouncement of judgment. The PC 243 of the 25.
Janagar is not connected.
Hey. Same thing. Order. Daily petition 3152 of 2025.
The bail petition is allowed, return back the case then. Let them connect. Proceed. That other matter I'll dispose it of, Boro. I'll dictate after court I'll dispose, chamber.
Item number 24.
May I please, your lordship?
Yes, sir.
Lordship, on the previous occasion, we were directed to bring a record, lordship. We have the record, but your lordship, the documents, the relevant documents in the record was submitted during the charge sheeting of the matter. The matter has been charge sheeted on 7th January 2026, lordship. And the NDPS case number is 8 of 2026, lordship. LCR may be called for. The matter is pending in District and Sessions Court of Kamrup Metro, lordship.
Milord,
Yes, it's commercial quantity.
commercial quantity, the only ground is that Milord, this is second bail application, that section 48 is not complied with. According to them, Milord, they have sub notice to my father, who has expired 5 months ago, Milord, from the date of incident. I've submitted the autopsy report, Milord.
But in the previous order, whatever rightly or wrongly I've held
Yes, Milord.
that there have been
Paragraph 9.
compliance with section 48.
Lordship.
48.
Isn't it?
And that document can be seen, lordship, in the TCR. TCR may be called.
That will be there.
According to them, Milord, they have served the notice to my
but-
father, who expired 5 months ago.
Then it will be, then maybe things will be different. Anyway, let us. A. Hussain.
R. Hussain,
R.
lordship.
Hussain, learned counsel, appearing on behalf of the NC, submits that the scan record comprising case diary and charge sheet.
Yes.
And maybe call for from the learned trial court, which is the court of learned session judge Kamrup Metro.
Lordship, Judge 1.
One additional session judge,
Lordship.
additional session judge number 1. Instead of the it is the petitioner counsel has raised the issue of non-compliance with section 48 BNS and stuff, and fairly submit that this is a subsequent bail petition. This is the matter. All issue requisition for the scan TCR comprising case diary and charge sheet and other relevant documents. This will do. From the court of additional session judge number 1, Kamrup Metro Guwahati. List all. You work out a date kindly. Both of you. When should I fix it? 27?
Lordship, 27. Highly obliged.
27.
25.
25 and 73 are same methodology.
23, 73.
73.
Save us time. Both are BA. Both are BA.
Lordship, yes, Lordship. On last occasion, CD was called for.
CD received also.
This charge sheet case.
Not charge sheet.
Not charge sheet, Lordship.
CD received also.
Because I saw the scan copy, that's why. What is the PS case of this?
Yes, case for
Hing PS.
Hing PS 270. 7.
One scan copy has come here. That's why I'm saying. Anyway. Scan had come without CD, then CD was called.
Yes, sir.
So we basically need the CD.
Right.
It's under investigation, right?
Under investigation.
Some threats, something of that sort.
Let's Lordship.
May please, your Lordship. Lordship, in respects of the accused petitioner in item number 25, Lordship, he has not been mentioned in his name is nowhere mentioned in the FIR, Lordship. Moreover, the Lordship grounds of arrest and reasons of arrest has been clubbed together and it is the same, Lordship. Whereas grounds of arrest has to be in personal in nature, Lordship. There is no incriminating material.
It's not named in the FIR.
He is not at all mentioned in the
during
FIR.
investigation.
And without his name also, the ground of arrest has been put, Lordship, in respect of the accused petitioner.
So several witnesses were examined statements recorded of the witnesses. Lordship. They have all them indicated this petition, Lordship. And they gathered in a bill area, Lordship, with weapons in Borobil Kasaribari bill, Lordship. Where they threatened to cut Assamese people. And dead body will throw in river Brahmaputra. That's such type of language is used, Lordship.
Lordship, that is only
And the
allegation.
videos are already broadcast in the social media platform. Lordship. Witnesses were implicated, Lordship.
Mr. G.R. Sila and counsel. And
May please, your
please be the son.
Disturbance petition.
I'll have a
Only thing
look.
is- Yes, Lordship. I have flag marked all the statements to the reporting. Releasing on bail, Lordship, they are harmful for the society, Lordship, threatening part of the city.
Not at all, Lordship. Lordship, when the IO himself stated in the checklist, point 7, Lordship. Lordship, page
Yeah.
38.
Police people.
Lordship, mein peruse
Whoever
page
does
38,
this.
Lordship. Lordship, in page 38, there is a column that is checklist for arrest without warrant as per section 35B3 of BNSS, Lordship. And here at point 7, the IO himself stated that there is no further requirement of the accused in discovery of facts. There is no further assistance required of the accused. He has categorically stated no, Lordship. And Lordship, in that respect,
His PC was not taken.
Lordship,
His police remand was not taken.
Not required, Lordship.
Was not taken.
The IAF himself stated in the checklist, Lordship.
Anyway,
Requirement of this is discovery of facts.
Hing case number 277 of 2022.
May I submit, Lordship?
Yes.
What I request, Lordship.
Complete.
The checklist for arrest without warrant at point 13, Lordship. As per section 35B, BNSS clearly records.
Yes.
Lordship, asking whether there is further requirement of accused in discovery of facts, the unequivocal acknowledgement by the investigating officer demonstrate that the presence of the accused is not necessary for any further investigation. When the investigating officer himself admits that no recovery, discovery, or investigative assistance is pending from the accused, then his continued detention becomes wholly unwarranted, and in such a case, Lordship, bail shall be granted without delay, Lordship.
Yes, the petitioner was arrested on 15/11/2025. The case arose out of an FIR dated 13/11/25, lodged by police official, in which nine accused persons are named and unknown others. The gist of the allegation is that the accused persons equipped with some weapons threatened to kill indigenous people and throw their dead bodies in the river. And they also circulated such video. It is alleged that such acts will create social grief. The present accused is stated to be not named in the FIR, but he was arrested during investigation. Mr. Sinha, learned counsel, has taken the court through the checklist in support of his contention that further detention may not be necessary. Specifically, it has been pointed out that IO has indicated as no with regard to the aspect of requiring his custody for discovering any facts. The case diary has been received. Learned additional PP opposing the bail submits that the witnesses have implicated the petitioners. Their statements are recorded. What do they say?
Their statements recorded, Lordship, but whole the statements are not in the case diary, Lordship. Only statements are recorded.
Can I have a look at the case diary?
Lordship.
The case diary is in place before me.
Raja.
In the progress of investigation, the statements of several witnesses have been examined. The statements of the several witnesses have been examined and their statements recorded. The investigation reveals incriminating materials. Investigation so far has revealed incriminating materials. Nevertheless, considering the progress of investigation and the length of detention since 15/11/2025, I'm of the considered view that the petitioners can be granted bail at this stage, subject however to suitable conditions. Number one, So 50,000 one security of the item. Subject to the following conditions, they shall not misuse their liberty to commit any illegal activities or any offenses, including any activities or offenses disruptive of public peace, social harmony. Full stop. Number two, they shall not hamper or tamper with evidence. They shall cooperate with remaining investigation. In case of violation of the bail conditions, bail will be liable to be cancelled. Return the case to. What about?
Value of lordship.
This one, same,
Same lordship.
but he's named in the FIR,
His name is not mentioned in the FIR lordship.
Not mentioned.
Years. Yes,
not mentioned.
not mentioned. I'm 70 years old lordship.
16/11/2020.
Length of
He was
it is
arrested on
65 days lordship.
16/11/2025. The petitioner is stated to be aged about 70 years. Full stop. There are implications against him.
Same.
Never really idea what is needed to do.
Both are fully implicated.
Only 50,000 with one suit. Otherwise, we should not take these elements seriously. However, we should be careful that they
CGM
don't actually start doing what
All
they are threatening. Otherwise, we should not take these
CGM knockout.
elements seriously. Something is
Obliged.
wrong here. Strict conditions. 50,000 one suit. This person. Okay. It number क्या है? It will 72.
At 29 days behind the bars, my lord. Okay, 29 days. The case diary was called for your lordship. It's a case of suicide, in fact, my lord. FIR, my lord, will find at page 40.
FIR itself mentions two witnesses.
Yes,
So we have to see them.
Earlier,
Tajuddin and Kamrul
Yes, yes.
Hussain and Fakrul.
Yes,
Fakhruddin.
yes, this is Murazar PS earlier, my lord, in respect of one accused, my lord, Mamun Rashid, my lord. He approached before this honorable court. Your lordship has perused the case diary, and thereafter your lordship was pleased to reject the bail petition. No, BA also, my lord. And ultimately, my lord, I will point out. Mamun Hussain, and I will point out, my lord. Mamun Rashid. Subsequently, bail was granted, my lord, by the learned trial court. He obtained the full bail.
Whatever, anyway.
And reason, my lord, page 23, in fact, he was engaged in molestation of one child, your lordship, page 23.
That's a bad incident.
Victim.
He's in custody since when?
My lord, 11/12/2025. 29 days to be.
29 days. Investigation.
And FIR was lodged in the month of June, your lordship. Any condition may be, my lord. Will face the
Your
trial.
lordship, earlier your lordship has, I will point out, my lord, your lordship has perused the case diary. This time also I have the case diary available with me.
Yeah, for the
regarding-
informant.
And regarding that, my lord, case of suicide, at that point also, my lord, I pointed out to your lordship regarding and why, my lord, IO has again, my lord, that report is available, my lord. At that again, my lord asked for a clarification regarding and also praying for a revised, my lord, PM report, my lord. And in this case, my lord, considering how the accused person is trying to influencing, my lord, at that point of time, I pointed out to your lordship regarding some of the my lord, witnesses. And regarding some of the, my lord, materials which was, my lord, observed by the investigating officer, I will may I read, my lord? My lord, gamusa which was used to hang does not
Where page?
my lord, that is not
In the CD,
in the
not the CD.
CD, my lord.
Okay.
CD, my lord. In fact, there are 4 witnesses, my
Yes.
before the incident occurred, my lord. There are witnesses how these accused persons are involved in assaulting the deceased, my lord. Regarding that aspect, and here, my lord, today, my lord, I have found 2 other witnesses, vital witnesses, my lord. One, in fact, my lord, that statement of one witness is recorded on 10th day of November, my lord. His statement is also vital, my lord. And Mamun Rashid, my lord, has regarding he disclosed something before that. That is, my lord, 183 of the statement recorded before the trial court, my lord. That statement is also available in the case diary. And regarding, my lord, why the earlier IO, my lord, sought for revised PM report, revised opinion regarding that PM report, that detail is also available, my lord, that the gamusa which was used to hang does not belong to the deceased. There was neither a bench nor a stool nor anything around which might have been used by the deceased to reach the loop of the gamusa to hang himself. Whereas mobile phone, my lord, all these things, my lord, I have flag marked, my lord.
All are implicated.
Regard 4 witnesses, my lord, vital witnesses. Your lordship may kindly peruse before the, my lord, date of the incident. How these accused person involved in assaulting the deceased, my lord. Regarding that aspect, there are materials, my lord.
This is a matter of trial, your lordship. If we are involved, my lord, we
They
will
are
be
named
convicted,
accused,
my
my
lord.
lord.
But a question, my lord, at this stage, we have already been custodial interrogation has already been done, my lord. I am behind the bars, my lord, from last 29 days, your lordship.
Earlier,
My lord,
these
this is bail, your lordship, not trial, my lord. In trial, if I am responsible, my lord, it will
apply the considerations of bail.
My lord,
Not the trial. Whether
regarding, my lord, we have not been named. They are saying accused persons, my lord. Whether I am that person or not, my lord. Simply saying will not do.
These people are not named in the FIR.
Named in the
Named in the
FIR, but the witnesses which my learned friend has read out just, my lord, they are not saying that I am involved. But so many persons, my lord, that will come out during the trial, your lordship. Regarding my instruction, my lord, I don't think, my lord, I don't think they also need, my lord, I should be behind the bars, my lord.
My lord, I will write there are 4 witnesses, my lord. I will write separately the name of those witnesses for your lordship, my lord, convenience. But I have also flag marked, my lord, regarding statement of those witnesses, 183 BNS, my
I'll
lord.
take it later.
Yes, my lord.
We'll take it later. We have time constraint to this, so let us move on with the other matters.
Yes.
Today only.
Chamber
বেশি হবে না, time constraint.
Order,
my lord, today your lordship will dictate to order. Because for tomorrow there is a vacation, my
No, I'll today only.
My lord, if I may point out.
Oh, sorry,
My lord.
Sorry.
Only, my lord, regarding learned public prosecutor has already pointed out. 2 things I will point out, my lord, regarding their conduct and the allegations which they have raised. My lord will kindly see at page 41, my lord.
Page 41
of the bail petition. Initially, my lord, when these present petitioners, along with the one which was arrested, they moved the anticipatory bail application, my lord. And there, my lord, in paragraph 7, your lordship has observed.
Okay, I remember now.
My lord.
I'm remembering.
Yes.
At that
Some
stage,
of the
your
facts.
lordship,
And yes.
that was the privilege of anticipating.
And secondly, my lord, the page 29, that also your lordship will pass the order. Para 7.
It is in respect of, my lord, Mamun Rashid.
Yes.
Not me, my lord.
These are all
He was
named
charged
my
on
lord.
bail, my lord.
Page 29. Because after this bail, anticipatory bail application was rejected, my lord, the present petitioners, they went into hiding. And this accused which was arrested, Mamun Rashid, he was caught.
Mahmood Rashid was arrested and subsequently he was enlarged. And so far as we are concerned, my lord, we surrendered before the police after rejection of
Okay, no, that's okay.
and 29 days, my lord, I am behind the bars. On the ground of that, my lord, your lordship may impose any condition, my lord.
All of later, all of save time. A Goel Learned Counsel. Page 42 of the second paragraph to second and third paragraph regarding the allegations. The Goel Learned Counsel for the petitioner submits that the petitioners have been in custody since their arrest on 11/12/2025. And perhaps their further custodial detention may not be necessary. It is submitted on behalf of the petitioners that they deny any involvement in the alleged offense. The case diary as called for has been received. The learned Mr. Bothakur, learned additional people, submits that the investigation has lent support to the allegations, and the statements of witnesses have implicated the accused persons. It's the learned counsel. Mr. Also appears on behalf of the informant, and he has drawn my attention to the earlier order regarding the petitioners, which however was a pre-arrest bail application. It is you are opposing the bill.
My lord.
Informant, the learned counsel for the informant opposes the grant of bail at this stage. I'll just study a bit and pass my. I'll go ahead again.
Deeply.
Don't worry.
Mine. Deeply.
If necessary, I'll get some food and stay here.
Oh my God. We are troubling your lordship.
No, why? It's our duty.
Fine.
We are here to provide you service.
Public.
Go ahead.
Unauthorized matter, judgment WPC number 243 of 2025. Remains eternal bench.
On considering the entire matter, the writ petition is allowed. The order dated 2/5/2025 passed by the respondents, awarding the contract in favor of respondent number 5 is set aside, and the contract shall be awarded in favor of the petitioner. The writ petition is allowed to dispose of. You took my time. You can disconnect, sir. Wait, chamber petition. Next.
May please, your lordship. Let's see, the petitioners are behind, before your lordship for the second time, lordship. Earlier rejected on lordship 12/12/2025. Lordship, they are behind the bar for last 57 days. And the only non-bailable section involved in this case is 3082 extortion. And the statutory period is 60 days, lordship. The updated lordship instruction was called for, lordship, pertaining to investigation. The allegation is that two people from Madhya Pradesh were induced to come to Guwahati and they were shown some tea garden and lordship Betelnut garden. Thereafter, their belonging and money and all were taken away.
Arrested on 14/11.
14/11, lordship.
90 days offense, my lord.
60 days, lordship.
90 days, my lord.
Correct.
My lord, on earlier occasion, my lord, that is on my lord, last, my lord, it
Which
is.
section is
60
90?
days.
90? No.
My lord, on 6, my lord, it has came, my lord. The matter came on.
3082 is the only non-bailable section. 3082 extortion. Maximum punishment is 7 years. The earlier 384 IPC.
Which one should I see? Any?
Yes, my lord, but this is updated one, my lord. Last, my lord, it has came on, my lord, that is 6, my lord. At that point of time, we don't have the updated CD, my lord. It is a case, my lord, when, my lord, the people, my lord, taking from outside to buy some tea and, my lord, betel nut. Then thereafter, my lord, they were kidnapped, my lord. They were taken to one place, my lord. And, my lord, taken the money and all other goods, my lord. And thereafter, they make a video of fake currency of 5 lakhs rupees, my lord. That was the case, my lord.
They were not kidnapped, they were lordship.
Earlier,
confined.
kind of kidnapping, my lord. Many
Confined
things may
room,
come
my lord.
out.
They,
Many things may
William
come out.
Secretary.
Investigation still going on, my lord. So, my lord, here, my lord, that is the updated, my lord, CD, my lord. Today we have, my lord. The here, my lord, one bail objection prayer is also made on behalf of the IO, my lord. And my lord, that is the, my lord, the race parties also, my lord. I have, my lord, tag mark, my lord.
Okay, at this, I am only lordship emphasizing on length of detention, lordship.
No.
Just 3 days left, lordship.
Oh, that you let us be clear about that.
Right.
You know, you think it is 90 days. He says
Yes,
it
my
is
lord.
60 days. Kindly cross check it.
308
Kindly cross check it. I don't know because I have not seen it.
lordship.
Because
Only
that
one-
will have a bearing.
Only one non-bailable section is there, 3082. Seven years. 7 years or fine or both. Others are bailable. 61-2, 127-2, and 351-1.
The IO has mentioned this actually. That
Yes,
that
madam.
is the earlier position. Up to punishable up to 10 years. So accordingly, he says it will be 90 days.
Up to 7 years.
That was he says that one of the section is punishable up to 10 years. Kindly cross check. We can be wrong.
Yes, madam.
We can be wrong. IO can be wrong. We can also be wrong. Cross check. It's a factual thing. I just
127 to wrongful complaint.
one
bailable.
second, 2 sheets.
Three zero eight is, my lord, 7 years, my lord. So, my lord, 60 days, my lord.
60 days.
3082, my lord.
Otherwise, IO has made some good points in his. He has made some strong points. I would
Yes,
say.
madam.
Good, I should not say strong points.
Yes, madam.
Yes, regarding that. But if it is 60 days, then it will be in the vacation. If another 2 days, if it's not completed, it will. 12th is open, district court, but thereafter it will open on 16th again.
Lordship, the conduct of the complainants are also doubtful, Lordship, because they have come all along from Madhya Pradesh, Lordship. It is not the way to purchase some tea garden, Lordship, from the conduct can be, Lordship, considered.
My lord, there is no restriction to come in, my lord.
Over
for my
telephone,
lord.
Lordship. Over
Definitely,
telephone,
my
they have
lord,
come.
that is
I
everything.
don't have experience of buying tea garden.
Lordship, that is. They were shown some
Because
garden.
these are the persons, my lord, they are, my
But
lord.
he is,
very much,
according
my
to the
lord.
IO, he is saying that very organized way. They are-
Very
they were
organized way,
lured to-
very
to
organized
our
way, my
state, you know, become tea planter and then.
And
royally
many things
treated.
have to come out.
Lordship, they've already undergone, Lordship, 57 days,
But
Lordship.
they are also
Thoroughly interviewed.
outside anyway. And Hassan and so I was page 18.
My lord, some stringent conditions, my lord. They have to till, my lord, that is the, my lord, that is the filing of the search sheet, my lord. Whenever required, they have to, my
Two
lord.
They will.
My lord,
surety.
along with the two sureties
They will cooperate.
and my lord, whenever required, my lord, they will, my lord, be there, my lord.
They will cooperate.
Till the, my lord, because, my lord, their link is there, my lord. Link is there, my lord.
Investigate.
Link is there, my lord.
They are from
And-
Kimpo only.
And my lord, that is all those, my lord, that is the mobile phones and all this, my lord, these things, they will, my lord, till then, my lord, because
Yes,
that, my
yes,
lord, part is going on, my lord.
good
They
points.
will hand over, my lord.
Yes,
Otherwise,
yes.
they will again, my lord, come and file a, my lord, Zimma petition, my lord. That will hamper.
Mobile phone,
and
Lordship, the police can seize, Lordship. There is no impediment.
There are 2, 3, 4 like same. The earlier bail petition, they are the same person, no? Subsequent.
Lordship, same, subsequent.
Petition was rejected on 12/12/2025 in BA 3865 of 2025. The updated the learned Mr. Hassan learned counsel commits that in the subsequent petition he mainly on the length of detention and submits that perhaps further detention at this stage may not be necessary. The updated case diary has been produced before the court. Mr. Voice learned additional PP opposing the bail has drawn my attention to the bail objection committed by the IO. I've gone through the bail objection where the IO makes some significant points and has points and has indicated that the accused persons had committed the alleged offence in a well orchestrated and premeditated manner and lured the alleged victims to Assam by online communication. Based on the penal provisions given, the applicable statutory period is 60 days. And so the detention so far is 57 days. The next few days are court holidays. In the given facts and circumstances, I accept this subsequent petition and petitioners so and so are allowed to go on bail 50,000 with 2 sureties of the like amount with the satisfaction of the concerned learned court and subject to the following conditions. Number 1, they shall not abscond, they shall not hamper or tamper with evidence. They shall be available for the investigation as and when required. They shall not misuse their liberty to commit any offences or illegal activities, and they shall not destroy or damage any evidence.
My lord, that is my lord, the violation of these conditions.
Yes,
yes,
that's sort of
that-
right,
that may be-
everything. In case of violation of bail condition, bail will be liable to be cancelled.
Deeply obliged.
Obliged.
49.
Yes.
May it please your lordship. My lord, your lordship will turn to FIR at page 6. My lord, the allegation is the theft of goat. So well, punishment.
Goat,
Yes.
E-rickshaw accident and they fell down.
Now, my lord, my humble submission before your lordship, as per seizure, my lord, goats are seized. And petitioners in detention, my lord, about 51 days. And another my lord, serious section has been given, that is 118 of 8 subsection 2. Grievous hurt by dangerous weapon. This section will not attract because, my lord, if your lordship see the FIR, it is the knocking of the vehicle. And as a result of that, somebody was injured. So rash and negligent driving only. By using dangerous weapon, grievous hurt, it is not the case. So, my lord, my humble submission before your lordship, as the articles are seized, and vehicle, my lord, on which we were driving, my lord, already damaged, totally damaged. It was in drain, my lord. So this is the situation. And the goats are seized. So nothing remained, my lord. And it is in the seizure list, your lordship would be pleased to see.
Yes. No problem.
My lords. On renewal car bearing register number, total damaged condition. There was hitting, my lord, and car went to the drain. And it is also in the FIR that there were 5 persons. 2 were arrested and the others fled away. This is the situation, my lord. After 51, my lord, my humble submission before your lordship, nothing remains that we will be in custody. No interest will be served, my lord. Only my freedom will be curtailed. Everything okay, my lord. This car is in damaged condition, seized. Goat seized, my lord.
I go to Palo, right? Last photo to first 3 paragraphs. C. Yeah.
CD not received, my lord.
Not received.
Not received.
My lord, CD not received, my lord. It was called for on 19/12/2025, my lord. Long time has been given. My lord, nothing will come in the CD. CD will say like this, FIR and this seizure list. That will be this simple thing, my lord. Your lordship would be pleased to see the forwarding report. Same CD will come. What is the forwarding report? That will be the CD.
Chaudhary Learned Counsel for the petitioner submits that the vehicle in question been damaged as revealed by the seizure list, and the allegedly stolen goats have also been recovered. Good stuff. The case diary as called for has not yet been received. On the earlier occasion also, case diary was not received. The length of detention is 51 days as on today. Issue reminder for the case diary. However, in the interim, the accused person is allowed to go on bail of rupees 25,000 with one security of the like amount with the satisfaction of the concerned learned court, and subject to the condition that he shall cooperate with remaining investigation, shall not hamper or tamper with evidence, shall not commit any illegal activities. This is the matter on. You can give a date.
Immediately, madam.
No, I gave interim.
Yes, madam.
So then we can give a little longer date.
Madam.
29 or something.
29.
29.
Interim granted, my lord. Oblige, your lordship. It is a CGM Lakhimpur, my lord. Oblige, your lordship.
CGM Lakhimpur.
30.
My lord, today is my lord 60 days. That is the statutory period. And petitioner has been suffering from my lord big poxes, my lord, inside the my lord jail, my lord. Now considering the my lord detention period.
Chickenpox.
Yes. Big pox, my lord. That is the my lord, why my lord second bail petition has been filed before this honorable court.
13 हो जाता है, sir.
Yes.
Well, in this matter, search sheet submitted, madam.
Can consider with. Itu agak apa lalu? Page 29. There are 2, 3, 4, 7. It is fairly submitted that an earlier bail petition was rejected on 12/12/25 in BA 3910 of 2025. The petitioner counsel submits that apart from the length of detention being 60 days, the petitioner is also suffering from pox in jail. The prosecution submits that investigation is completed, resulting in a charge. In view of the same, the petitioner is allowed to go on bail of rupees 40,000 with one security of the like amount, satisfaction of usual conditions.
SDGM. The search sheet number is there.
5 CS number 70/25 dated 18th Parliament.
That may be kept as a part of record, madam. Communication.
Petition stands allowed and disposed. Allowed and disposed.
CGM, my lord Kokrajhar.
CGM Kokrajhar.
CGM.
May I please? My lord, item number 31 and 49 out of the same FIR, my lord.
49.
And 49.
Okay. Go ahead.
My lord, 31 is the regular bail application, my lord. I have been arrested on 15/12/2025, my lord. The FIR is at page number 10. Allegation is that the petitioners entered into the house and set fire upon the dwelling house of the informant. What happened, my lord? There are going since long a land dispute between the parties since long. At this stage, both the parties amicably settled the matter outside the court. One affidavit also given, my lord. Page number 3, my lord. So, my lord.
Your page number?
Page number 13.
Yes, yes.
Sorry, my lord. Page number 19, my lord. Informant given an affidavit, my lord. They have amicably settled the matter, my lord. And she is no more interested to proceed. Upon miscreants created the offense method, committed the offense method. Where the residence of my lord Kumari under Boko police station, incident occurred at 12 River Police. So, my lord, both the parties amicably said.
ideally that agreement should be part of the CD actually. They should always
yes, my lord,
submit
that,
it.
that I have not found in the
One
CD, my
copy they
lord.
should always submit, you know.
Yes,
I know.
but in the petition, my lord,
I
they
trust
have-
you.
my lord.
You know, the thing is that, but it's always better from procedure
My-
point of view.
my-
That it should be given to the IO.
My lord, I will,
So that then you will tag it with the case diary.
my lord, I will furnish. the
Because
original.
nobody is appearing.
My lord, I will furnish the original.
You will dispose it of.
Item number 31, my lord, he has completed 26 days, my lord.
Mm.
And my
TDS
lord,
come.
under item number 49 is the anticipatory bail.
TDS come.
Serious come, my lord. Witnesses, my lord, the victim has, complainant has implicated, my lord.
No other.
Now, if, my lord, if they have, my lord,
that-
compromised the matter, my lord,
That is different.
then I'll leave it to your lordship, my lord.
Yeah. You don't have the original, no? Now you don't have.
My lord, I will furnish the original affidavit.
No issue.
Before the IO.
No, it's okay.
My lord,
Okay, I'll go by this one. No worries.
my lord.
When you give me the diary.
My lord, yes. The-
Application BA, so and so. Third A Pramanik 1000. RJ Bodo. 483 bail application. Kualkusi PS case number. River PS, Kualkusi River PS, 66 or 24. The petitioner was arrested on 15/12. In regard to an FIR dated 1/12, in which 7 persons are named. And the informant has alleged that on 27/11/25, when she was, when her husband was not at home, the accused persons entered her house, used slang language, pulled her out, and set fire. And later, upon her neighbor coming, they fled away. The Pramanik Learned Council has drawn my attention to copy of a affidavit made by the informant. Which you stated that she has settled the matter with the help of in a village meeting, and there is no objection to grant of bail. The case diary has been received. Learned additional PP points out that in her statement, the informant has implicated. Then this must be a subsequent development.
My lord.
The subsequent.
My lord.
Because anyway, seen the progress of investigation. Keeping all the aspects in mind, and also length of detention, the petitioners are hereby allowed to go on bail. Petitioner is allowed to go on bail at 25,000, 30,000 on security. So the condition shall not hamper or temporary dividends. He shall not in any manner cause any harm or harassment or threatening of the informant or other witnesses. Violation will. The other one is anticipatory bail. 30,000 with one security, satisfaction of each.
Learned JMFC Hazu, my lord.
Satisfaction of the concerned learned.
Learned JMFC Hazu.
JMFC Hazu. Same conditions. Same condition. Dispose. Both disposed. Okay.
Highly obliged.
May it please your lordship. My lord, the allegation FIR is at page 14, my lord. My lord, the allegation is regarding one comment on Facebook, my lord, regarding the Redford blast, my lord. And he is behind the bar for last 58 days, my lord. He was arrested on 13/11, my lord.
In this case, my lord, search investigation completed, my lord, search is submitted.
My lord, learned coordination, my lord, another bench, my lord, given bail, my lord, on similar situation.
Mr. Sarkar and RJ Board.
That is in respect of Manikpur police station case, my lord.
Okay. The case was registered with regard to a alleged Facebook post given by the petitioner making certain supposedly disturbing comments regarding the bomb blast incident near Red Fort recently. He was arrested on 13/11/2025. The learned additional PP submits that in this case, investigation is complete. And investigation is completed, resulting in a charge sheet. Same PS, this is
No, my lord.
different.
This is related Bongaigaon PS
No, no,
case.
The search number is, my lord, 133/2025, dated 11/12/2025. 12/2025.
Good, sir. Without going into the other aspects of the
Yeah, I go to CD to
the allegations, etc. Considering the completion of investigation and the length of detention, dash the accused is allowed to go on bail of rupees 25,000 with one surety of the like amount, subject to the condition that he will be available with trial if one commences, and secondly, he shall not enter or tamper with evidence and shall not commit any illegal activities.
Highly obliged.
The petition stands allowed and disposed of. You want this? You can take it back. Give it back to
68 case that he received, my lord.
Today is 37 days, your lordship. He was arrested on your lordship. Four 12/2024, 25 your lordship. FIR is at page 18, your lordship.
Yes.
Your lordship has
Remembering now.
on two occasions has gone through your
Yes,
lordship. My case is basically your lordship length of detention, your lordship. Since your lordship already 37 days behind bar, your lordship, everything has been seized, documents, etc. has been seized, your lordship. Probably further custodial interrogation is not required, your lordship. He has disclosed whatever he can, your lordship. That is one aspect, your lordship. And secondly, your lordship, my ground was, your lordship, that since it is these offences are, your lordship, less than 7 years, your lordship. Now, they ought not to have, petitioner ought not to have been arrested, your lordship. That law has already been settled by this honorable court by series of judgments, your lordship, from Ernest Kumar to your lordship, Satinder until your lordship. That when these offences are under 7 years, your lordship, and in fact, the 35(3) notice to be the first course of action they should adopt, and thereafter, your lordship, if they find any reason for that, they can arrest, your lordship. That's the law, your lordship. Now, these are the two grounds, your lordship, based on which I am seeking bail. Mostly, your lordship, that since it is already 37 days, your lordship.
Case that he received, my lord. Otherwise, my lord, the issuance of fake certificate, my lord, that is under investigation, my lord. So as far as the accused person is concerned, my lord, 37 days as on today, my lord.
Yeah.
But investigation is pending, my lord, because there are also other accused persons, my lord.
What happened? Just he had a center, no?
I had a center, your lordship. What has happened? I took your lordship affiliation from the center at Nalbari, your lordship. Now that center has your lordship no affiliation from that have lapsed your lordship affiliation. In fact,
Okay.
that has created problem. In fact, I myself is a your lordship victim in the process. I have annexed the affiliation certificate, your lordship. Only considering the length of detention and of fact that it is, they should have your lordship. In the meantime, arrest has been effected, your lordship. Although they should not have. So considering that aspect, if your lordship.
As Batago, council and RJ Board, the basic crux of the allegations in the FIR dated 3/12/2025 is about issuing of fixed certificates pertaining to certain vocational institute. Full stop. The petitioner, Nalbari PS case number 338/25 was registered, and the accused was arrested on 4/12/2025. Full stop. Mr. Botago, Learned Counsel, submit that this limited contentions are that regarding the ground of the detention so far. Semicolon, that documents have already been seized. It is also contended that considering the sentences pertaining to the penal provisions, the police ought to have complied with issuing a notice under 35(3) BNSS instead of arresting him straight away. The case diary has been received. The prosecution has not disputed the length of detention. However, investigation is stated to be in progress. It is submitted that by the petitioner side that the petitioner had a center and had taken affiliation from an institute, whereas the affiliation might have had lapsed. So in a way, he had also suffered at the hands of such an institute. In the given facts and circumstances, I allow this bail petition, and the petitioner is hereby allowed to go on bail of 50,000 with non-saving, subject to the condition that he will render full cooperation to remaining investigation, not hamper or temporary difficulties, and not commit any illegal activities. Return case there is postponed.
Your Lordship. Case diary was called for, my lord. Annexure 1, page 12, my lord, FIR. The recovery of gold and iPhone from the vehicle of the petitioner, my lord. He has been arrested on 27/11, my lord. 44 days has passed, my lord, and investigation has already been completed, my lord.
Case diary not received, my lord.
And my lord, in the meantime.
What is the allegation?
Allegation, my lord.
Gold.
Page 12, my lord. Recovery of 7 pieces of suspected to be gold, 2 iPhone, my lord. From his
Rectangular
vehicle.
gold biscuits.
And my lord,
Yes, my lord. Recovery of 7 pieces of gold recovered, my lord, 7 pieces of gold biscuit, my lord.
charge
And
sheet
he
has
could not
already
produce
been
any.
filed, my lord, as per my information.
But not come into the record.
My lord,
That information we do not have, my lord, that we have to obtain.
my lord, the father of the petitioner is a cancer patient, my lord. I annexed my lord 21, my lord. And considering the detention period, my lord, those charge sheet has already been filed for my information, my lord. Petitioner, my lord, may allow to go on bail, my lord. He is only male member, look after his father, my lord. Page 21, my lord.
His name is Najib Ali.
Rajiv Ali is a Rajiv Ali petitioner, my lord.
No,
Saleh Ahmed, my lord.
Saleh Ahmed. Najib Ali, who's Najib Ali? Is the father.
Father, Najib Ali.
Father's cancer.
Father's cancer.
No plan. Okay, will you take instructions or what to do?
That we have to obtain instruction, my lord, regarding filing of the search sheet, my lord.
Yes, my lord, I confirm, my lord.
Let my learned friend, my lord, obtain the search sheet.
Kindly, record
It
my
will be
submission,
easier.
my lord. Record my submission.
No issues.
And my lord, detention, my lord.
BA or BA, sorry, you written BA 482. Anyway, it's BA, right? 480, her age, dear. BA 483, Vashishta PS case number, so and so. The accused was arrested on, he was arrested on 27/11/2025. The gist of the allegations is about recovery of 7 pieces of gold
Suspected.
rectangular gold from him, and it is alleged that he could not show papers, and therefore the said gold is suspected to be of doubtful antecedents. Nevertheless, the learned counsel contends about the length of detention and also points out that the father of the petitioner is a cancer patient and that petitioner is a only earning member. However, case diary is not a precedent. The learned petitioner counsel submits that as per his clear instruction, as per his clear information, investigation is completed, resulting in a charge sheet. The prosecution shall take instructions regarding the same and also issue requisition for the fresh requisition for the case there. However, in the interim, the accused is allowed to go on bail of rupees 30,000 with one severity, the satisfaction of the concerned learned court. Which is the court? This is Murajha Hojai, CJM Hojai.
CJ, Kamrup Metro.
Yes. Kamrup Metro.
But it's a
Subject
PS
to the
case.
conditions that he shall cooperate with, he shall not hamper or tamper with evidence or commit any illegal activity. Interim bail, list on.
My lord, list on my lord. 28/1, my lord.
28/1.
My lord.
Interim, I have given. Interim.
Obliged.
My lord. My lord, CD was called for.
Case diary not received, my lord.
And this will require case diary, I think.
Considering the days of detention, my lord, 85 days as on date, my lord.
What is exactly alleged? Because her daughter was, guess there's domestic help.
Yes, she was working as a domestic. Actually, what happened, my lord, her mother, she has been a domestic help for last 18 years. With
Her
the
mother?
petition. Yes, mother, 18 years. And although it is not pleaded, my lord, this is knowledge, my lord, she's a drunk, she used to take drinks quite often in the home, my lord. That is why she had kept her daughter in our home, my lord. So though she is in our home, but she is not a domestic help per se. She also earlier had went to school and all. But what happened on the day, my lord, she was there in the house, and the petitioner, along with her driver, went to Tinsukia, my lord. And for shopping purposes on the eve of Diwali, my lord. So what happened during her absence? She committed suicide, my lord. And she also went to the nearby village just prior to the incident. It is documented, my lord. She went to a nearby village, my lord, and had a chat with some people there, including the house of the driver. That driver's house is nearby, my lord. So when at around 1:30 she came back. So and during that time, only the husband of the petitioner, who is a dementia patient, my lord. Dementia patient. He used to reside there, and the daughter, she came back from her job at around 2 to 2:30 p.m. And immediately when she saw, she rang up her mother. And mother came after half an hour or so. She came back from Tinsukia. And
they noticed that she was found hanging, my lord. And there was also a leather, the leather found in the nearby the place of occurrence, my lord. So immediately police came, my lord. Police then they took the petitioner along with her driver to the nearest police station, and she was arrested. Now, one thing, my lord, I want to show. Kindly come to the forwarding report, my lord, page 27.
Page 37.
27, my lord.
27.
27. It says at point number grounds of arrest, my lord. 4. The family members of the deceased reported that the victim has been previously tortured. Then, my lord, 6. Presence of accused persons at the scene of crime before arrival of the complainant raised suspicion of complainant regarding commission of the crime as mentioned in FIR by the accused persons. So she was not there. She came back at around 2:30, and I have also annexed one cash memo. She had done purchase at Tinsukia, my lord, page 25, my lord. This is the cash memo. She was not there. It's a prima facie material that she was not there.
Okay.
And also, my lord, just another one point, my lord, page 17A of the FIR. This is the form 17A, my lord. It says type of information written, my lord.
Yeah.
And kindly come to then page 20. Page 19, my lord. Page 19. Actual affair, my lord, actual complaint. She has put her thumb impression. So that it must have been written by someone else, my lord. So that is no indication in the affair itself, whether it was reduced to writing. That was not there, my lord. So my humble submission, my lord, she is not at all engaged with the crime, my lord. So considering, my lord, the case in hand, my lord, also her husband is a bedridden, my lord, dementia patient. I have annexed one certificate of doctor at page 30. And she was being, my lord, within the police custody for only 1 day.
Anyway.
So I pray, my lord, the application may be disposed of today itself, my lord. Otherwise, there is no point of calling the CD again, my lord. Because today is to 85 day.
No, since the case diary has not received, my lord, and it is also not sure, my lord, whether investigation is pending or not.
Yes, no, I think we
So
should.
lordship may pass some interim order, my lord, otherwise.
So
Otherwise, it is also difficult for on our part, my lord.
And my lord, the inspection memo, kindly see, my lord, the inspection memo, it says there is no external injury, my lord. Kindly see, my lord, page.
I've seen.
Yes, my lord. Page
Inspection
24.
memo of the petitioner.
No, of the dead body, my lord.
Dead body.
Yes. It says no external injury, my lord.
Anyway, so. The petitioner was arrested on 18/10/2025 in connection with Juliajan PS case number 179 of 25, which was registered based on an FIR dated 18/10/25 lodged by the mother of the deceased, stating that her daughter / deceased was engaged as a domestic help in the house of the petitioner, and on that day she committed suicide. She has given allegations of torture and also mentioned about one boy named Aditya Devnath. The learned counsel, apart from drawing attention to the length of detention, has also stated that submitted that the petitioner completely denies the allegations and that her husband is a dementia patient, and drawing attention to the annexed document. It is also submitted that the inspection memo pertaining to the dead body of the deceased indicates no external injury. Case diary was called for, have not yet received. Considering medical condition of her husband and the length of detention. In the interim, the petitioner is allowed to go on bail of rupees 40,000 with 1 COV to the satisfaction of the Naharkotia.
Duliajan PS. Duliajan.
Duliajan, JMFC.
Dibrugarh.
CJM. Concerned learned person within bracket CJM Dibrugarh, when subject to the conditions that he shall not hamper or tamper with dividends. Issue reminder for the case diary. I think in a case like this, it is necessary to see the case diary.
31, my lord. 331.
74 same, my lord, driver.
Driver.
Yes, sir.
Who-
He was also not there, my lord.
He's not named.
No, his name, my lord, but he was not there.
Aditya Devnath.
My lord.
His name is Aditya Devnath.
Aditya Devnath, yes. He was all along with the petitioner, this petitioner, my lord, Sunita Desi.
Arrested on same day, right?
Same day, my lord, same day.
Same order. Same order. The instead of petitioners on the house, petitioner's house. The petitioner, present petitioner is stated to be the driver of the co-accused so and so Daisy. You know, what is her name?
Aditya Devnath, my lord.
No, her lady.
Sunita Desi.
Sunita Desi. Co-accused Sunita Desi.
Deeply obliged.
Which date did we give? 30.
31.
31.
Okay.
30 January.
Obliged, my lord.
No.
May please, Your Lordship. Well, this application was earlier rejected by your lordship during investigation, my lord. Here, what has happened, my lord?
Which one should I take up first?
75, my lord. Here, my lord. Each gentleman, he has a, of course, I'm saying gentleman, my lord, he is behind bars. He has a plot of land, my lord. And that plot of land, he bought it on the basis of a false power of attorney lodged by the present victim, my lord. He sold it to me, my lord, by duping the original owner and myself, my lord. To that effect, their lordship, I placed it on the earlier occasion. To that effect, there is a case. In that case, his bail application was rejected. And thereafter, he was kidnapped. His bail application was rejected. In the case wherein I bought the plot of land and he duped the power of attorney, my lord. He duped me, my lord, by forging the power of attorney. That was the FIR is dated 2710. That he was kidnapped. Immediately he was found out, my lord. And section of law would be 127(8), bailable, that I placed before your lordship on the earlier occasion. And thereafter, my lord, he moved a bail application. I lost 7 cases against him for duping me. And the landowner also lost the case against him. In that case, his bail application was rejected on 7/8/25. Whereas the FIR is lodged on 27/10/25. He is pally with the police, my lord, despite rejection by the High Court. It is not a, my lord, law that when High Court rejects it, police is to arrest him. I am not saying that. But he is in the good books of the police. On 27/10, when he was kidnapped, he recovered immediately. Even then, he was not arrested. Kindly see. Of course, my lord, when the machinery fails, people take help of Lasit Sena, Alpha, all these people. Normal human tendency, my lord. The government machinery failed. I lost 7 cases against the person who duped me. Page 61 is one affair. Page 95 is one affair. Page 142 is one affair. Page 144 is one affair. Page 98 is a title suit. My lord, despite this, my lord, charge sheet has been submitted. Of course, my lord, charge sheet has been submitted. Now, my lord, there is an interim prayer also in my application. If they oppose, my lord, I should not oppose because pointless. Keeping a man in jail where the first informant himself has duped me and my lord, after his bail application being rejected, he was allegedly kidnapped, immediately found out, not arrested. Another open sky, my lord. So kindly allow me to go on bail, my lord. And lordship, why rejected it on the earlier occasion? That speaks volumes, my lord. Page 166, my lord. I'll not read much, my lord. Page 166, my lord. Last paragraph, my lord. my lord, two paragraphs, if it is read in totality, my lord, 11, 12. 12 I am reading, my lord, I am not taking much of your lordship's time. Despite progress in the investigation and the length of detention so far, I am of the considered view that keeping in mind the nature of the alleged offence, the incriminating materials, it may be prudent to refuse bail at the moment and allow the investigation to progress further.
Like
My lord,
your
it has
opinion.
progressed to the hill. CSI will never run away, my lord. This much, my lord.
Is there a charge sheet submitted in this case?
Charge sheet submitted. And diary has come.
The charge sheet submitted, diary not come. Intimation was made that charge sheet submitted. By CS number 69725, dated 13/10/25.
Will write. Page 163, previous order. DK Mahajan, council, and DP Jaswani. It's fairly submitted that this is a subsequent bail application, as an earlier petition was rejected on 18/12/2025 in DA 3990 of 25. Upon perusal of this diary at that stage of investigation. The updated case diary was called for. However, it is submitted by the learned additional people that in the meantime, upon completion of investigation, final form has been submitted by way of a charge sheet by its CS number
697/25, dated 30/10/25.
In view of the completion of investigation, it would be fair and just to allow the subsequent petition. Accordingly, petitioner is allowed to go on bail of 50,000 at once unit, subject to the condition that he shall be available for trial if one commences. Number two, he shall not hamper or tamper with evidence. He shall not commit any illegal activities. The petition stands allowed and disposed of.
Highly obliged, my lord. Obliged, my lord.
And, these are all connected. We have
Connected,
taken
your
one
lordship.
by
Your
one. Then
lordship
the
was-
next 53.
Lordship. Your lordship was pleased to, your lordship, reject the bail application, your lordship, on earlier occasion, your lordship. Third sheet has in the meantime submitted, and in fact, your lordship, these three petitioners are neither named in the FIR, your lordship.
Okay.
They were arrested from
Yeah, just a
Lords.
The earlier bail petition was rejected on 19/12/2025. First three paragraph. Para 2, 3, 2. I find it at page 25. 2, 3, 4, 2. Stop. Sorry.
Lords. That is your lordship. Since charge sheet has already been submitted, your lordship, and your lordship further for the purpose of investigation, they are not required, your lordship. They may be allowed to go on bail to face
Sorry,
trial.
please submit. Okay, okay. So 53 is done. Then next is 76. And 7. All are BS.
BS, your
All are
lordship.
BS.
All are BS.
They were arrested date to believe.
76, 77, 78.
76 he was arrested on 28/10, Silogo. 28/10. And previous rejection was, date was
All your lordship. 1912.
1912. Same.
Other two cases also same.
Same date of arrest.
Lord.
Same date of arrest. Same date of rejection. Others is also same.
Lord.
All disposed of.
Lord.
Number attack of. These also 25, 76, 78, 53. All disposed. Allowed.
Lord.
All allowed and disposed of. Motions. Huh? Here we go. AB stuff. Motion. AB ni. Get us a motion. First. Can we have you can guide me how to, because we have to complete all bail, respective of time. The 7 new matters are there, then some cases where interim is there, but CD has not come there, we can extend. And give a date or something. You can just keep a list, not now, meanwhile, while I proceed with this, you can just keep a track, how many matters it has not, CD has not come, but interim is there. Then we'll start. I'm taking the new matters, unlisted motions. Seven.
May it please your lordship. This is the same case, lordship. Other accused, police in civil days, lordship, picked up the man, lordship. Already granted bail, lordship, to the co-accused, lordship, in item number 72 day, lordship.
We gave interim. I think.
Yes, lordship, interim bail granted, lordship. Fixing on to
668 any.
No.
Item 6 only.
see 70.
70.
Which item number?
70, lordship, BA 5 oblique
70.
2025. 6.
Same as 70. Same as 70.
Yes, lordship.
Same as 70. BA 57. Same as 70. Next.
7 is also same, lordship.
BA 1999. Same as 70.
Highly obliged.
Interim. Date is 28, I think.
Yes,
Not
lordship.
this one. Date is 28. 28-1. Both the cases.
To
28.
the satisfaction of CGM Lakhimpur North.
We have written in that.
Yes.
Already.
Production.
May I please your lordship?
74 I took.
74 no.
AB 72. AB 72.
AB 70.
My lord, this is suicide, my lord. The informant closed the Izahar on the ground that her minor daughter of 16 years age committed suicide. And this FIR was lodged after 56 days of the incident. My lord, the incident took place on 18/8/2025 and the FIR was lodged on 13/10/2025, my lord. 56 days. The allegation is that the boy is 19 years old and the girl is 16 years old. There was a love affair in between the two, but there was no love affair. Whatever may be, my lord, the present petitioner is his elder sister of the victim.
Okay, you are not for Jannat Ali.
I am not Jannat Ali.
So
I am the elder sister of the alleged accused number 1. I am the Surja Banu, my lord. I have minor daughters, sons and daughters, my lord, and
the allegation is against Jannat Ali.
accused is Jannat Ali, not and nothing was stated against the present petitioner.
Oh, love affair, that's unfortunate, of course, but I was really concerned because here there is allegation about sharing of some, obscene photos. Anyway, but she is the elder sister.
Elder sister, my lord, and having minor son and daughters, my lord.
Mr. Boysa?
Yes, my lord, she is accused number 2, otherwise.
And nothing is alleged in the FIR.
In the meantime, my lord, my lord, there is a statement may be recorded.
Yes, yes.
Statement may be recorded.
And Dekiajuli PS case number 271 of 25. The petitioner is arraigned as accused number 2 and in the FIR dated 13/10/2025 regarding the suicide of the informant's daughter who allegedly was having love affair with the accused number 1. The petitioner is stated to be the elder sister of the said accused. Said co-accused. The allegations are directed mostly against, mainly against. There's nothing actually against them. The allegation is mainly directed against
accused number 1.
A1, accused 1. All for the case diary. However, in the meantime, interim 25,000 at once will cooperate, record as taken, not cause any harm to the informant. This is the matter of, you can give it on 2nd February something.
My lord, 27? Or any date, my lord?
2nd February.
2nd February. Yes.
Highly obliged.
May I please, Your Lordship? Lordship, the FIR at page 7, Lordship. The allegation of building sexual intercourse on the promise of marriage, Lordship. That is the allegation, basically. Whether custodial interrogation will be necessary, that is the fact. I am ready to appear and cooperate with the investigation, Lordship.
Heard.
Yeah, Mohammed.
Yeah, I know. Alright. It is alleged in the FIR giving rise to this case that the petitioner, the last 8 months, was having a legal relationship with the informant with a promise to marry. And 30 lakhs he has taken.
Yes. Lordship, it is written in a vernacular also like that. 30 and then
He
lakh.
taken a large amount of money from him also. And thereafter stopped communication. 30 lakhs.
Absolutely vague allegation. Lordship.
He must be a rich person. No, must be. 30 lakhs.
Definitely.
Anyway, let's stop. I have perused the narration in para 4 of the bail which he stopped. Call for the case diary. However, in the interim, 25,000 with one savings. Conditions are standard. He shall not cause any threatening. He shall not threaten or harm or harass the informant in any manner.
I am obliged.
It's fixed on 2 February.
May it please, Your Lordship. Lordship will find the FIR, my lord, at page 15, my lord. 15, my lord. From 3rd paragraph, my lord. During this period, a verbal argument took place between us, and taking undue advantage of the situation, the accused person recorded the said conversation on his mobile phone. Later, the matter was temporarily settled through one mediator, Sofikul Islam of Hatsingmari, and then I paid an amount of rupees 50,000 to the mediator's account for the accused on the condition that no news would be published against me thereafter, my lord. My lord, then next paragraph, my lord. Recently, my lord, the accused person has demanded rupees 10 lakhs as a final settlement amount. When I refused, he again threatened me to make the previously recorded audio conversation viral with the intention of defaming and blackmailing me. His continuous acts of extortion, intimidation, and blackmail have caused me severe mental stress and harassment. So this is a case, my lord. Now, Lordship will find below, my lord, the accused person is Sopiur Rahman. Lordship has seen, my lord.
Sopiur Rahman.
So SOPIOR Sopiur Rahman. Now, my lord, what happened, my lord? That, my lord, in the 3rd paragraph, my lord, Sofikul Islam, the mediator, my lord, he was arrested, my lord. That your lordship will find, my lord, at page, my lord, page 20, my lord. Forwarding, my lord. That's mediator, my lord, Sofiul Islam has been arrested, my lord. Now, my lord, that this Sofikul Islam, my lord, had preferred a bail application before this court, my lord, where the, my lord, informant has stated, my lord, that he had no objection, and accordingly his bail was granted, my lord. Can I hand over the copy, my lord? Lordship, have a thank you.
And this petitioner is?
This petitioner is the wife of, my lord, this Sofikul Islam, my lord. Well, she has been served a notice, my lord. Paragraph 5, my lord. Today, the learned counsel for the informant has submitted that he has no grievance against the present petitioner, and therefore he has also filed an application before the trial court stating his no objection. Learned counsel for the informant has no objection if the present petitioner is allowed to go on bail, and accordingly his bail was granted. Now, my lord, your lordship will turn to the last page, my lord.
that is page 24, at 35, 3 BNSS notice is served upon me, my lord, who happens to be the wife of my lord, the mediator, my lord, Safiqul Islam. My lord. This is my case.
Third NJ Dr. Lanet Council.
She has been given 35 notice, man. Let her appear before the
I will appear.
investigating authority.
I will appear. I will appear.
Invoking 482 bail application. The petitioner is seeking anticipatory bail in South Salmara PS case number 173 of 2025. Next up. She is stated to be the wife of one Safiqul Islam,
Yes, madam. Safiqul Islam.
who's Safiqul Islam, who along with another Topiur Rahman are named in the FIR dated 11/12/2025, lodged by the informant. Indicate the full stop. Apart from other details, the gist of the allegation is about one of the accused stated to be a journalist, blackmailing him with demands of money, telling which he shall publish some negative news about his construction work, about his construction work. So, here is the brief report of the preliminary inquiry. It is the Dr. Lanet Council is placed before the court, order dated 8/1/2026, passed in BA 36 of 26, in which it is mentioned in para 5 that the informant appearing in that case, in that bail application arising out of the same affair, has stated about there is no objection to grant of bail to the named FIR named accused Safiur Rahman. The petitioner has received the notice under 35(3), BNSS, and has some apprehension of arrest. Call for the case diary, however, in the interim, 25,000 of funds saved, we shall cooperate, appear.
Me too, my lord.
I am obliged, my lord. Deeply
This law of, notice, actually, that it has been done in for a good thing. The person has noticed, but otherwise, because this notice is given, but every time a notice is given, there is an apprehension of arrest.
Yes.
So every time a notice is given, there will be an anticipatory bail. Suppose you make a modification in the law that if the person appears pursuant to a notice, then within a space of 5 days or 6 days or suppose a week, he cannot be arrested. So that if he sees that he may be arrested, he can seek
And my lord,
only if he seeks, sees the possibility of arrest, he will prefer a anticipatory.
and when my lord 35 notice is not served, my lord, violation of until council, my lord.
That is true. The whole purpose is to prevent unnecessary arrest, actually. Unnecessary arrest only when it is really necessary. That is the objective. Any short break.
Production check number 6. 98 after 226.
Maybe the lordship, this is 376 million. By the page 10. The new 64 million.
Okay, this is. Yeah. Tamul, what is this allegation?
Page 10 is the FIR, the 64 of the BNS file.
Diary will be necessary. Diary will be necessary.
So one thing is there, my lord, that other boy named in the FIR, he's a minor, my lord. That is why there was a.
Who's he? G2 Das.
I'm G2 Das, my lord.
There are 2 accused persons.
That person, the first person, my lord, I'm not say his name, my lord. He's a minor, my lord. Should we come to page 4, para 7, my lord? As per my instructions, are written down the story, my lord. They had a relationship, my lord. The victim girl and the minor boy, my lord. Due to which, there was an uproar in the village, my lord. Subsequently, several events occurred, my lord.
Para 7, my lord, lordship sees bonds, my lord.
Because he's named in the
Otherwise-
FIR also.
Yes, named in the FIR, my lord. Otherwise, my lord, very serious, man.
Uh,
My lord, that boy is a minor, my lord. That is why this FIR has come up. My lord.
Who is a minor?
Accused number 1 in the FIR, my lord.
Acha. Joy does.
Yes, man.
It does. Anyway, let us get the case diary. Fix it after
Case diary.
reopening.
My lord, on 20, my lord.
Call for the case
20.
diary of Tamulpur PS case number 1 of 2026. 6 on 20. He was arrested on 2/1 2026. 2/1 2026.
I'm obliged, my lord, highly obliged.
Road 8. Production list 8.
7 to 9. 7 to 9. Oh, अच्छा, अच्छा.
Same to that Supiur Rahman.
The allegation, my lord, physical assault is there, my lord, in the vital part of the body.
No, this is the. This is pertaining to that case we just. That extortion journalist.
Yes.
Extortion. Supiur Rahman and Safiqul Islam. His wife we just granted.
No, this is not the case, my lord. That it is, my lord, regarding one publication of news, my lord. That lordship will find the FIR, my lord. Is
What is the case number? AB?
AP number 93, my lord.
90, yeah.
Yes, lordship may kindly come to page number 22, my lord.
Page?
Page 22.
But this is a different thing.
This is different, my lord.
Oh, it's the same accused, but his
Name is same.
in that FIR there's an allegation that he's doing with others also.
Yes, my lord.
Blackmailing. Anyway, it will not be-
Nobody has appeared, my lord.
Nobody has appeared. You can call for the case diary. Time constraint. There's a meeting also at
My lord,
4:30.
then
I have to finish the bills.
Yet then, my lord, Passover matter, my lord. Let it come out 19, my lord.
Call for the case diary.
My lord.
None appears. Full stop. Schedule the FIR. Full stop. Call for the case diary of South Salmara PS case number 173 of 25.
22-1, my lord.
Timing item 22.
22-1. How many timings are there? Timing के पास. Timing के पास. Just a minute. Bro, AB लगा सब.
Madam, we have.
Meeting this सारा साइड. Just a minute. AB hearing supply strong itu হবে স্যার. এটা হবে স্যার. 81 82 বাকি আছে. 81 82 বাকি আছে. বাকি খালি নরমাল. হ্যাঁ? যাই. To run a little fast. Yeah, 22.
Item 22, my lord, we have obtained information, my lord. In this case, search is submitted, my lord.
He's an interim in any case, isn't
There is an interim. My lord, may I kindly submit, my lord?
We'll make it absolute.
Yes, my
Is
lord.
it?
Already because, my lord, there's 43 days, we were already in detention, my lord, before being granted the interim bail.
Uh,
To what my lordship is just stated.
yes, yes.
It may kindly be made absolute. my lord.
But I don't know, I've not gone into the.
My lord, one more point, my lord, the applicant number 1 has an infant child, my lord, who was born in March
Is it a-
2025,
it's a
and the
case of
second
ga-
applicant is a disabled person.
It's a case of gang rape.
Gang rape.
That says, anyway, interim must have been given for some reason.
My lord would find order dated 24/11/25 interim.
Due to delay in
Delay also, my lord, plus it is also observed by the honorable court that looking into the facts and circumstances of the case, my lord, these facts were considered, my lord.
Yes.
That it is a
Anyway,
fake case, my lord.
Okay.
For
Call for
arising out of
the,
personal enmity.
the petitioner was granted interim bail on 24/11/2023. That's right. In this, good stuff. The case diary was called for, but it is submitted by prosecution that in the meantime, investigation is completed, resulting in a charge sheet. Now you say whether to, should we call for the, see the merits of
My
the.
lord, my humble submission, my lord, that the scan will be called for,
Yes,
my lord.
that will be
Because
better.
there will be materials, my lord.
Because the allegations and after
Yes.
all, it's our duty actually to see this. Call for the scanned case report comprising case diary and charge sheet and other relevant documents, full stop. Interim bail stands extended till the next date of listing. List on
29/1.
29/1.
Obliged, my lord.
May I please question? Lordship, 59 and 47 is out of same affair, Lordship. Maybe taken together, Lordship. And
47,
in 47 city receipt.
47, my lord, then my lord, my
Bail
lord,
hearing.
has gone through, my lord.
Bail hearing,
Bail hearing.
AB bail hearing, then we'll
Yes.
take it up together with that.
Yes, Lord.
We'll take it up.
Elamur attended for 47, my lord. 47.
No, it's not bail hearing, AB.
Article case diary not received, my lord.
Case diary is not received, full stop. Issue press reminder, in the interim bail stands extended till the next date of.
There is last chance has been given there.
No,
So long time.
no time today. We have to complete. There's a meeting also for that. Interim stands extended, list on. Give a longish date,
My lord,
please.
on 4th of February, my lord, 4/2.
4/2.
Your Lordship, my senior is on legs. Court number.
Let us do one thing, madam, let us.
Kindly adjourn the matter.
We have
Diary is-
received the case diary, my lord.
Okay. Case diary, will do one thing, time constraint, just the case diary is received.
Let it be on 19, my lord.
Yeah,
Your Lordship, may I extend the interim.
yes, the interim, however, to some time constraint. Matter may be posted on 19th, the interim bail starts standing extended in the next date of this.
Highly opposed.
35.
36.
35.
Your matter, 35, 36,
Your Lordship.
both are,
Both, Your Lordship.
35,
The
36.
35, Your Lordship, the petitioner is a Lot Mandal in the Nagaon Circle Office, Your Lordship. He's an interim bail. He has recorded his statements, Your Lordship. per my
Diary has come.
instructions.
Diary has come, my lord, and my lord, there are sufficient materials collected by the IOM. So this is not a fit case, but to grant him, my lord, interim protection.
Lordship, FI is on page 10.
Absolute interim protection, my lord.
Lordship, the only allegation against him is that he has not made field verification during the registration, before the registration of the sale deed, Your Lordship. Your Lordship, you knows that the field verification of the Lat Mandal is not necessary, Your Lordship, for registration of a sale deed.
Yes.
Now, for that, my lord, subject to correction.
Well,
my lord.
Can you flag mark it?
Yes, yes,
We
yes.
will dictate it.
Yes, ma'am.
Later in the chamber. Otherwise. I will write down your points.
So everything, the matter pertains to, Your Lordship, documentary evidence, Your Lordship. Whether custodial detention will be required. Because the only allegation is that he has not made field verification before the registration of the sale deed. And it is not required, Your Lordship, to make field verification before registration of a sale deed by Lat Mandal.
Itu das, itu details. ma'am. Details.
Lordship, in item number 36,
Yeah.
there is no specific allegation against him as per the FI. FI is on page 9, Your Lordship.
Yeah. What about the other one, other person? Shubham.
Both are the, my lord. One is Latmandun, my lord, and another one is the, my lord, also associated, my lord. They executed one, sold it, my lord, who was later on found to be fake one, my lord. A report was also obtained from the, my lord, sub-registry, office of the sub-registry, my lord. Wherein, my lord, they have verified and they have said, my lord, it is a fake one, my lord.
Till now, investigation is not complete, Your Lordship. A matter of June 2025, Your Lordship, charge sheet has not been submitted till now, and the matter, the documentary evidence is required, Your Lordship. So custodial detention may not be required, Your Lordship. Moreover, the petitioners have cooperated with the investigation.
Okay, I've noted it down.
Lordship.
Both have appeared, no? The
Lordship,
statements
they-
have been
Statement
recorded.
recorded, madam.
Statement recorded, they are cooperating.
I have recorded your point also.
Lordship.
They both are not appropriate cases for.
Appropriate cases, my
that's
lord,
what
and
he
my
said.
lord, sufficient, my lord, material has been found against them, my lord.
The matter raised on documentary evidence, Your Lordship, custodial detention may not. be
I'll see.
required, Lordship.
Right. Right.
The CD will be required, my lord.
Yes. This is CD.
No, that will be retained, my lord, CD will.
I'll give it.
My
back.
lord, my lord.
Today only all orders are to be
My lord.
signed, uploaded.
38.
Lordship, oblige, Your Lordship.
May it please your lordship. 482 application, my lord, petitioners on interim, my lord.
My lord, in this case, my lord, investigation completed, search is submitted, my lord.
The petitioner was granted interim bail on 29 October. Huh? Was granted interim bail on 29/8/2025. It is submitted by prosecution that charge sheet has been submitted. In view of the same, the interim bail is made absolute, subject to the condition. He shall available for trial, not hamper or temper.
Well, I may be allowed to approach the learned trial court and 15 days time may be granted.
No, I'm making it absolute. Then
Absolute.
you just appear and
Yes, yes.
furnish fresh bail bonds. I'm making it absolute.
Deeply obliged.
40 case that is not the same, my lord.
Case diary not received. Issue press requisition, interim right order dated 5/9/2025 stands extended till the next date of listing. List on
29/1.
29.
41.
Case that is not received, my lord.
We are on interim, lordship, two petitions.
Case diary not received. Interim order dated 29/10. Same date.
2/2, my lord.
2/2.
2/2.
Okay.
Obliged. 42 also case that is not received, my lord.
Lordship,
here
this is
he's
the
not-
third, lordship, this is the third occasion
He's not on
has been
interim.
not received, lordship.
He's not unable this time.
We are in not interim, lordship, so.
Sorted the.
It's a case of one person has died.
My lord, it is why, my lord.
What is the allegation?
Lordship, this is a murder case, lordship.
Murder case.
So, lordship, out of the same incident, 2 FIR was filed. In the
Mhm.
both the FIRs, name of the petitioner number 2 has not been mentioned.
Mhm.
And so far, the petitioner number 1, in one case, petitioner number 1 has been implicated, lordship. So, case is murder, lordship. Their involvement is nothing, lordship. They being the relatives of the prime accused, their name have been implicated in this case, lordship.
Prime accused is?
Was the accused persons, lordship.
The prime accused is Monuar.
Those actually, lordship.
Let the case diary come.
Wait for some time. 19 or 20?
21, man.
21. Case diary is not yet received. Must issue fresh reminder to positively send the case diary for the next day. Fix on, what did you say?
21/1.
21/1.
Search is submitted, my lord.
43.
On interim, my lord.
Petitioners were granted interim 3/12/2025. Prosecution submits that in the meantime, charge sheet submitted upon completion of investigation. In view of the same, the interim bail made absolute subject to trial, not temporary.
CS number 191.
Shall not misuse their liberty to commit any offences or illegal activities. By CS number
191/2025 dated 31/12/2025. 44 also search sheet submitted, my lord.
same case, different case. You are there. The petitioner granted interim on 3/12. Charge sheet submitted, make it absolute.
CS number 3/2026 dated 6/1/2026.
Please, your lordship. I'm on interim.
Yes. Interim is there.
Interim is just case diary not received, my lord.
Extended
3/2, my lord.
4/12 interim.
Obliged.
Which date is that?
3/2.
Not received. I should remind. Interim. Sorry. This is charge sheet.
No, my lord. CD not received, my lord.
Oh.
Earlier one search sheet submitted.
It's the bhul. 3/2.
47 and 59.
May I please, your lordship? Lordship in 47 CD receipt, lordship, and with the petitioner out of same affair, lordship.
47 and 59.
Lordship, I don't know about 59, lordship, maybe taken such. FIR is 17, lordship.
I take 47 first.
Yes, same affair, lordship. FIR is 9, lordship.
Yeah,
And
please.
item number 47 filed by FIR number accused number 4, lordship. And item number 59 has been filed by 2, 3, 6 and 2, 3, 5 and 7. Now, lordship, the main accused is lordship Zohrul Islam. He has been granted bail, lordship. He was
Investigation is complete in this case.
No, my lord. CD received, my lord. Still going on, my lord. It's very nascent statement. One is apprehended, my lord.
But someone has been granted bail.
Yes, lordship.
I also, it was ringing in my
My lord,
mind.
that-
This. Somebody was
I
granted.
think that is a regular bail. That is a regular bail application, my lord.
A regular bail.
Regular bail.
But lordship, everything was recovered from the version of the Zohrul Islam, lordship. Nothing has been recovered from the present petitioner, lordship. And allegation is preparation of docket, lordship. No incident was committed. And that is also on suspicious ground, lordship.
Wife's pregnancy, length of detention, regular
Yes,
bail.
my lord. Because of that, my lord. Now,
Regular
my lord, there is a preparation of dacoity, my lord. 310(4), my lord.
Regular bail.
This is a case, my lord.
Mhm.
No doubt, my lord. 60 days offense, my lord. That is
These are
10 years.
anticipatory bail.
These are anticipatory bail, my lord. Now here, my lord, the case is that, my lord, that is the my lord, apprehended accused who was granted, my lord, bail, my lord, regular bail, my lord. My lord, from his house, my lord, that is, my lord, the uniforms of the police, my lord. That is, my lord, recovered, my lord. From the source, my lord, it is, my lord, known to the police that, my lord, the gang is there, my lord, who are using the, my lord, attire of the police, my lord, in the, my lord, that is the midnight. They do the dacoity in the, my lord, highway. From his, my lord, statement, I am not revealing, my lord, not only these people's name. Now they are contention in, my lord, item 47. They stated that they, my lord, in this way, my lord, that the petitioner begs to submit that the allegation made in the FIR are false and cognitive. The petitioner is no way involved with the LS incident. The real fact of the case is that the petitioner and the other accused person hail from the nearby villages, and as such, they are known to each other. All of them jointly started business supply vegetables from their rural areas. So that is there, and because of that dispute, my lord, some dispute arises, my lord, he took the name. That was their story, my lord. But to support their story, nothing is there, my lord. Now it is a case of, my lord, that is the preparation of dacoity, my lord. It is now in the very nascent stage, my lord. And, my lord, there is a note, my lord, from the IO, my lord, that may be, my lord, look, my lord, look into, my lord, that walkie-talkie is used, my lord. And that, my lord, that particular walkie-talkie, my lord, that without, my lord, license in India, my lord, that is banned, my lord.
Encrypted.
Yes, my lord.
I told you. no?
Yes, my lord.
New technology is being used.
Yes, my lord.
Checks,
And
what
they
checks?
stated, my lord, that during the time of dacoity, my lord, when we are wearing the, my lord, that is the uniform of the police, my lord, we don't use the mobile phone, my lord. We are using, my lord, that is the, my lord, this walkie-talkies. So many things has to come out, my lord.
So
But lordship, annexed to the seizure list, lordship, nothing has been recovered from the
Obviously, my lord.
petitioner lordship. Everything was recovered from the Zohrul Islam lordship.
Who has
So-
been granted bail?
Yes, lordship. So, lordship, moreover, lordship, the police has found sufficient time, lordship, more than 2 months, lordship.
লগাই থব দাস চেম্বার
Here, your lordship, CD was called for, your lordship.
This is the, my lord, Cricket Association's case, my lord. It is.
One CD is with me.
Yes, my lord.
That one?
Yes, my
Oh, sorry. You want that? You want the CD?
My lord, because my lord, to my lord, make my submission, I need to, my lord, go through.
One of my order is half done.
Yes, my
Half
lord.
done. So I have to,
Yes,
factual
ma'am.
part I have written,
Yes,
discussion I have to write. I'll write today.
Yes, my lord.
So he should have the CD, I think.
Lord.
I've gone through the CD partly, but I've gone through from perspective of that person actually.
Yes, my lord.
Some Thakur or something.
Yes, my lord.
Amit Sinha, another person. You make your submission, please.
Lordship. Lordship, FIR is at page 20, your lordship. This FIR, your lordship says, your lordship, this is to bring to your kind notice that recently it has come to the knowledge of the association that the following players, namely Amit Sinha, here the petitioner is Amit Sinha.
Yes, I remember. Some
Abhishek Thakuria,
trying to
Ihsan Ahmed,
some-
Amon who
make
played
some
us.
manipulation of
No.
the thing.
This is the allegation since your lordship has gone through. But the foundation of this FIR is the page 22, your lordship, which is the your lordship preliminary inquiry. This is important, your lordship. Based on this preliminary inquiry, the FIR has been lodged. Now, your lordship, so far as this preliminary inquiry goes, your lordship, in nowhere my name is to be found, your lordship. Your lordship has found, your lordship. In fact, in the order granting interim bail, your lordship has recorded everything, your lordship.
Name is there.
Yes, your lordship. And your lordship, before that, your lordship, I have appeared thrice, your lordship. That's your lordship may kindly go through, your lordship. It will be this. Thrice I have been called, lordship.
Submitted, that's enough.
Lordship. Now, your lordship, in page 23, your lordship will find persons examined, then summary of the incidents, your lordship, and 2 bowlers, your lordship, name of 2 bowlers, then summary of suspicious overs. Here also the question of my name being, they are not. Now, your lordship may kindly come to page 25. Page 25 onwards. 26 says, Aman Tripathi text player Nihar Deka asking ki khobor, he called him on WhatsApp and stated, तुम्हारा मेटर खुलता ही 22 में अगर आप डील करे तो आपको 7 लाख रुपए मिल जाएगा. This is by one Aman. Your
Page 22.
26, your lordship.
I think. Oh, yes, my Abhishek Thakuri, this mail is.
Lordship.
Please. No.
Then your lordship, this is suspect is Abhishek Thakuria in incident number 3. Incident number 2, your lordship will find Aman Tripathi.
Yeah,
And then analysis of statement and evidence. 2 confirm direct
Oh.
approaches were made. Your lordship will find page 27 by Aman Tripathi and Abhishek Thakuria. Then both approaches involve clear financial inducement to manipulate match performance constituting corrupt under ACSU BCCI regulations, presence of known suspicious individual, Aman Tripathi, Isan Ahmed have been previously suspected linked to cricket-related illegal activities. While no conclusive evidence of wrongdoing is established at this stage, this is important, Your Lordship. Lordship. While no conclusive evidence of wrongdoing is established at this stage, the expensive overhead by so and so combined with their subsequent meeting with so and so warrant deeper monitoring, internal team atmosphere, then conclusions, Your Lordship. The conclusion also, Your Lordship, will find that nowhere my name is there, but suddenly at serial numbers,
You mentioned it.
Lordship, 6, Your Lordship, my name cropped up, Your Lordship. Now, in fact, Your Lordship, since 2021, I have left playing cricket, now in business, Your Lordship. Construction. So, Your Lordship, on the face of it, Your Lordship, prima facie, Your Lordship, it cannot be alleged that I am anywhere, purely based on suspicion and FIR has been lodged, Your Lordship, and my name has been brought to in. And secondly, Your Lordship will kindly note, Your Lordship, 3 days I have been examined, Your Lordship, and my mobile phone has also been seized, Your Lordship. I have surrendered that mobile phone, Your Lordship, on being seized. And Your Lordship, my statement has also been recorded. I have cooperated with the investigation as per the direction passed by this honorable court, Your Lordship. At no point of time I tried to evade investigation, Your Lordship. And finally, Your Lordship will also see, Your Lordship, ultimately these offences, Your Lordships, are less than 7 years, Your Lordship. Now, in an offence of this kind, Your Lordship, normally they should have issued 35(3) notices. They should have issued 35(3) notices. That has not also not been done. And Your Lordship has seen this until judgment, Your Lordship. It's very clear.
Relevant paragraph.
Lordship. Ernest Kumar to discussion. Your Lordship may kindly first take Ernest Kumar, Your Lordship. Your Lordship knows about Ernest Kumar, Your Lordship. The para 11, last but one page onwards, Your Lordship, of the judgment. Your Lordship has seen it was related to 498A, but subsequently, Your Lordship will kindly see para 12. We hasten to add that direction aforesaid shall not only apply to those cases under section 498. And in Satinder until, Your Lordship, the Honorable Apex Court, Your Lordship, in para 100.2, Your Lordship, it says the investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and the direction issued by this court in Ernest Kumar. Any of dereliction on their part has to be brought to the notice of the higher authorities by the court, followed by appropriate actions. The court will have to satisfy themselves on compliance of section 41 and 41 of the code. Any non-compliance would entitle accused to grant of bail, Your Lordship. That is 100, if popular decision.
Case diary you see and then.
Lordship.
Well, I need some time. I need some time,
I'll go through the case.
Yes, yes.
Otherwise, Your Lordship, I have, Your Lordship,
I've noted all your
cooperated
points.
with the investigation.
I've noted all your. Can I keep this?
And Your Lordship will kindly see.
Can I keep?
Your Lordship will keep it. Your Lordship will kindly see another aspect, Your Lordship. Both criminal breach of trust and Your Lordship,
They can be.
420 cannot come together.
Alternative
Your
charge
Lordship.
at the stage of trial, otherwise
Lordship.
both cannot.
Lordship. Recent judgment of the Apex Court also, Your Lordship, reiterated that position. This is my submission, Your Lordship.
With that, let him go to the case diary. Let's move to the next thing.
Lordship.
Because I
Deeply obliged, Your Lordship.
Finish also.
You are
Yeah, hold on. Maybe hold on.
কোনটো 81 টো ছাৰে কৰিব মাতি দিয়ক
My lord, the arguing
Yes, you're for the informant.
respondent, my lord.
Respondent.
That's not two.
Yes, tell me.
My lord, the
My senior is joining virtually.
my lord, the arguing counsel is indisposed. He is undergoing physiotherapy. So a death may be fixed.
Manoj, I think he's speaking, but he's on mute. Huh?
81.
81.
I came 81.
51, 51.
You said 51.
81.
51 हो रही है.
My lord, am I audible, my lord? My lord, am I audible? My lord?
No, it was actually 81 was called. There's a bail matter. You just hold on.
Oh,
You can log out.
sorry, my lord. I was under impression that it's 51, my lord. Sorry.
Yeah, you can log out. I'll get back. We'll get back to you.
Number 81.
Diary has been received.
Diary received. 81.
What if case diary was called for? Learned senior colleague, Mr. J. Sutia, he has gone through that. He's coming, my lord. He's coming. After some time.
Just a minute.
Oh,
Second.
second to go down.
Maybe hearing. বাকি কি আছে মানে বেলর ভিতর কি বাকি আছে সাবমিট তো দিকে because বেলর কি বাকি আছে সাবমিট সাবমিট every hearing আছে yeah if you want any ticket you are for 81
Lordship, they are saying after some time.
we have some time constraint actually 40 meeting is there 4:30.
CD received, Lordship.
We have
Let the
almost
PP
finished.
come, Lordship, after some.
We have finished almost. Actually, only 2 matters are left as far as bail is concerned. No other bail. 81, 82. Only 2 bails left. Yours and another one. Are they connected? No.
No, not connected.
Then we'll take the next one. 82.
No.
80, come. After some.
82.
May I plead, Lordship? The anticipated bail application, Lordship. The petitioner come before Lordship in a CID case, Lordship, and before that, Lordship, one case has been registered in Jorhat, PS case, Lordship, and that case already court has gone anticipated bail,
No,
Lordship.
that was in connection with another case.
No, same apartment, Lordship. I will show, Lordship. Lordship may come to page 40, Lordship. 40.
Oh, sir, I have recorded.
Yes, Lordship.
Oh, it was called for CD. CD has come.
Yes, come.
Yes, page.
Page 40 is the interim order, Lordship. Initially 8/10/2025, interim protection granted by Lordship. 8/10/2025 on page 40.
All right.
Thereafter, Lordship said order made absolute on 4/11/2025, page 43.
All right. Okay.
And petitioner
after getting the anticipated bail, Lordship, complied to all conditions imposed by him and already appeared before the investigation authority on several times.
You're saying that the allegations of this case and the allegation of that case are same.
I will show completely same, Lordship. Lordship may come to page 28.
If that is true, then they should be amalgamated in a way.
No, it is second FIR is not mandatory in the eye of law because TK Anthony, ratio laid down in TK Anthony
That will be
cases.
yeah. Well, that will be a 161
Yes,
statement in a
Lordship.
way. The allegation is there cannot be two facts over the same allegation. Anthony, right? Yes. I'll have to see the diary properly in any case.
Yes.
inside. So you make your submissions. Huh?
Zuhat case FIR will find, Lordship, in page 31.
You're up here.
Here, Lordship, against two accused person FIR was lost. One is Sujit Dutta and another is present petitioner, Lordship. And the incident really elaborated in para 1 on the 21st August 2025 at around so and so. I was called by Sujit Dutta to meet him at a Dogan Athanic restaurant, cafe, Jorhat, and demanding some allegation of demanding rupees 11 lakhs, but they have not received a single money. There are some discussion with the corporate sector, Lordship, for construction of a statue of in the name of Bir Lassit and another amount for party organization, Lordship. But they have not received a single penny. That's why the Honorable Court has, after perusing the case, their Lordship, anticipated bail was granted to me. And Lordship, the present FIR, the CIDPS case, Lordship will find page 13 onwards. Page 17 is the Lordship may find page 17. The name of the accused person has been shown here. My name is in serial number 3, Lordship. And now Lordship will find in this FIR there are several district crime has been elaborate offences committed by the Bir Lassit and Lordship, and my part has been reflect on page 18, Lordship. Para 5. Same date, Jorhat, August 2025, early August 2025, major incident, Jorhat brought BLS illegal activities to national attention. Again, and City Guard Mall, same offense. Yep. So there is no new on this second FIR relating to present petitioner, Lordship. But other person who are arrested, they are something different, Lordship. My part only in the entire FIR, my allegation is in para only 5. That Jorhat case reference. That's why, Lordship, I pay for, because already court has granted anticipated bail in Jorhat PS case, original case, and the second FIR is not mandatory, so I may be allowed to go on bail, Lordship. This is my humble prayer, Lordship. And Jorhat case, so allegation is concerned 11 lakhs, they have not received a single penny from the corporate sector, Lordship. Only they have this discussion part, Lordship.
No.
This is my prayer.
Some
The allegations is against him, Lordship, in the EDS FIR regarding the Jorhat case also.
it's identical, then obviously
identical,
legal
but-
might be a legal bar.
Legal, but only thing is that Lordship, materials are there in regarding the condition threatening and demanding money as their Lordship.
In the Jorhat PS, investigation is not completed.
Not completed. Petitioner is on anticipated bail, he appeared
They can
on several occasions, Lordship.
generally, from the point of view of the IO, they can continue investigation in that case.
Yes,
Yes,
but
I will be ready to appear, Lordship. I
only thing
will,
is that Lordship, here Lordship, the CD part is 12/11/25, last part, the last date of entry, 12/11/25, so far.
that is something different, Lordship. Already in original case, court has granted bail, Lordship. I appear on several occasions.
Last
My
10
statement also recorded.
No, it's okay. I get your point. I get your point.
Obliged, Lordship.
And so this is the thing. Any case, CID is also looking. CID is looking into the general.
In general, in
and
several
they
districts, Lordship.
also filed a petition for amalgamation.
Yes.
They
Yes.
filed. Once
Yes.
it came before me also. I think.
Place of occurrence on several districts, 5
Yeah,
districts.
It came before me
And
also. one day.
petitioner is
filed a
concerned only
petition-
Jorhat.
They filed a criminal petition or writ petition, I don't know, writ petition criminal or what, for amalgamation of
Lordship.
at one place. Anyway. So give me the case
Lordship,
that,
I will flag mark it and then Lordship.
yes. It will look like it. Mr. Munir, you can submit.
No,
Or some.
obliged, Lordship.
You can make your submissions.
Lordship. Submission means, Lordship, the as per the FIR contention, yeah, says that he was abducted by the 3%. Later on, he came to the name of this accused person, name were mentioned in the FIR, that they have taken his mobile phone and snatched away 10,000. Later on, he came to know that they are the member of Bill Lasit Sena. This is the allegation for that purpose. Then later on, later part of the FIR on page 9, it says that I was not aware of the names of the accused at the time of occurrence, but subsequently when I came to know about their name and when I contacted them, they assured me to return my cash money and mobile phone. But till date, they have not returned the same. As such, there is delay in lodging the FIR. He had a contact with this accused person. That they have got some other transaction, for that they have taken this. And later on, he have mentioned that they are the member of the Lasit Sena. That will reveal from the case diary whether they are member or not. That part only. I think for that Lasit Sena, at the motion stage, the bail was not granted. Now CD is there. If they are member of that part, then lordship.
They have a great name. Yeah.
Lordship, look at the statement of the arrested accused is there. And his statement is that the petitioner was along with him with another person, and the person snatched the mobile and cash pointer.
Wow.
That organization is not a, it's a
It's not a
legal
bad
organization.
It's
It's
not
a
a bad-
lawful organization, isn't it?
No,
It's
at
not a
that
bad
point of time
organization.
when at motion stage, that some
No,
persons were
but
picked
think
up.
that since it's not,
no,
it's a legal organization, so with
but
a
at that time, some
illustrious name tagged to it. So if suppose members do indulge in this kind of activities, it brings bad name.
Lordship, that was in a training, Lordship, when a few persons were arrested for their activities.
Anyway, so any submissions or I'll go through? Your mark.
The three statements are there, my lord, as the request lordship will look into it.
If custodial detention is required or not, that part may be considered into Lordship. Otherwise, he is not a habitual offender, Lordship. That part may be considered. Lordship is rising.
Huh? Oh. No, I don't. Other matters, obviously, there's a meeting also, and in any case, there's time constraint. So 19, anybody there for, you are for that hearing, no? Let us fix a date after the vacation, and we can fix it on a, you can hear me, Mr.
Yes, my lord. My lord.
Yes. You have been anxious about the hearing. It's part hard. We'll definitely hear it. Let us fix it on a hearing date, and we can take it up at 2 p.m.
My lord.
It on a hearing day.
Kindly give some precedent because matter is of 2024, my lord.
Huh?
Matter is of 2024. So, my lord, kindly give some precedent.
Matters pending. Anyway, every matter is important. You can suggest a date, but don't
My lord,
take
any date, my lord, as you
part
lordship
hard, right?
convenient.
Okay, don't take the next week because I'll have to go to Aizawl next week. There's some
Oh.
change. I'm going to Aizawl next week. Next week.
Mr. Lord could probably suggest.
Yeah, so you can suggest, we can take it in the last week of Jan.
29, my lord.
How about 3rd at 2 p.m.?
3rd
3rd of
February.
February at 2 p.m.
My lord.
Yes,
My lord.
3rd of February at 2 p.m.
My lord.
In petition, 19 part hard to word, bold করে দিব, bold. 20,
May it please your lord. My lord, item 20, my lord, here, my lord, scan copy were called for. I have gone through the record. The particular scan copy has not come. My lord, may I pray that entire original record may be called for?
It is against conviction.
No, my lord, against 20% deposit under 148(3)(a). I leave it to your lordship, my lord.
Usually nowadays scan copy is only accept for disposed of.
My lord, yes, my lord.
So let us call for, you are saying it's not very legible.
No, that application has not come as it appears from the record.
Okay.
The earlier order. Your Honor, whatever record is available, that is sufficient for us, but my brother is not.
Okay, I'll
happy.
We'll take the file and then I will pass an order. Any case, we have to adjourn it.
Yes,
So you work out the date.
Or 28 may be fixed, my
No,
lord.
after that. No,
28.
Some dates we should also leave to registry because otherwise.
What year? What 3rd March, my lord. Hearing day.
3rd March.
Yes. Oh, so, sorry, my lord. 3rd February. 3rd February.
My lord, item 19, it's a part heard matter, my lord.
Just a minute.
Item 20.
Let it be on 5-2 if it's not inconvenient for both sides. 5-2.
Yes, yes, no
5-2.
problem.
5.
My lord, 6-2, my lord.
6-2 is motion day.
No problem.
Okay, I can fix it. I can fix it. Motion day, but
Yes.
6-2.
Obliged.
Okay, 6-2.
My lord, 6-2, I have some other problem. Because
I can give you anything, but
My matter
5
is
or
fixed
6
on
both, I have
6-2.
no problem. You have to decide.
on 5 it may be fixed, my lord.
5.
And interim order may be. Yes, no problem.
Item 21.
My lord, item 19, it's a part heard matter, my lord.
Yes, 19 is part of that.
My lord.
So yeah. এটা আমি মই ভুলকে দিলো এটা বস্তু that hearing matter আমি fix কৰিছিলো না that hearing matter we fixed it on ভুলকে কৰিছো 51 is we fixed it on 3rd at 2 p.m. 51 item 51 19 is also part heard 19 is also
Yes,
part
my
heard,
lord,
right?
19 is also.
So similarly we can fix another date on 5th at 2 p.m.
My lord.
5th at 2 p.m. Part heard
2 p.m.
2 p.m.
My
It
lord,
will reach for sure.
Much obliged.
And hearing day we can take.
Yes, yes, definitely.
My lord, item 48, my lord. That 48, no, 48, my lord. That is the Cricket Association's case, my lord. I have gone through the CD, my lord. My lord, here in the, my lord, that is the bail objection, my lord. That is the objection regarding, my lord, this present accused petitioner Amit Sinha is also there, my lord, available. And his involvement in the similar line with, my lord, the earlier, my lord, Thakuri is there.
Obviously.
Only, my lord, the point of law before your lordship is that what my learned senior colleague has submitted SK Until's case, my lord. Yesterday also I have mentioned, my lord, regarding that is the notice of, my lord, now in BNSS 35
Unlike
3, my lord.
here 45, 47, 48.
Yes.
35 notice.
35 notice, my lord, because, my lord,
may not make it fatal. I have to read more.
because, my lord,
understand
it
more.
is applicable, my lord, if, my lord, the arrest is made, my lord. SK Until's case, if arrest is now it is a, my lord, pre-arrest bail application, and, my lord, during the course of investigation, if, my lord, I am being the investigating agency, I am not issuing 35(3) notice and knowing the information, if somebody appears before the court, my lord, then, my lord, things remain dead. His statements is recorded. So that is my submission, my lord, regarding that point, my lord. Otherwise, my lord, that is the CD is available. I have, my lord, tag mark all relevant part.
Rest, you take.
Lordship, item 50 on 21, Lordship. Item 50 on 21, Lordship. It's only for a delay condition, Lordship, that we have. 21. Much obliged, your Lord.
83, 84, you take dates, no? 83, 84. Anybody from there? You.
No one is. My lord. Happy. এইটো কাৰ ফোন কৰি
Yeah.